21 CR 4408, we're outside the presence of the jury. We do want to clarify for the record that yesterday we referenced a Defense Exhibit 14, which also was referenced as Defense Exhibit A. But it is one and the same exhibit. We never really marked A or circulated it. But A is not an exhibit that was marked or offered at all. It was Defense Exhibit 14, which is their offer of the video recorded statement that was broadcast, their offer in order to make it an optional complete exhibit. That was denied, and so it's being offered, and it's going to go up and made part of the record on appeal in this case. That's not an exhibit that the jury will consider. So we just want to clear the record up on that.
And that is correct, Judge, in our understanding.
Are we ready for the jury?
Yes, Your Honor.
Are we ready?
All rise for the jury.
Thank you. You may be seated. Good morning. Welcome back. Thank you for your patience. I had to take care of some other judge duties that I have to respond to when things are hot. And so that happened this morning, but otherwise we were ready for you guys. We're still, Freeman, if you could please come on up. You're still on the stand. This is still cross-examination. Mr. LaHood, you may proceed.
Thank you, Your Honor.
Give him a chance to get settled up.
Yes, ma'am. Good morning.
Morning.
So yesterday, I believe, Ranger, we left off on June 13th. That refresh your memory a
Yes,
little bit?
sir.
And that was the day that was the day after that Susan Tristan had called you, and this was the next day that you guys had met at that address in your report.
Yes, sir.
And then we talked about what she handed over to you, and so I showed you those documents that have been admitted into evidence, these cash logs, and then I taped them on the board to your left, correct?
Yes, sir. However, as I look at my report, that first meeting, I have copies of receipt book, but it included cash logs.
Well, remember we talked about that, and I had asked you, why do we call this a receipt? Because it has a receipt on there.
Okay. Yes, sir.
Remember that?
Yes,
okay.
sir.
And so we did yesterday was just take out the cash log portion of it, and we taped that on the board.
Okay.
Correct?
Yes, sir.
Okay. And then I think the question we left off on, that your meeting with Ms. Tristan on June 13th was not recorded.
That's correct.
And so we essentially have to take your word for how that meeting went, correct?
Yes, sir.
In general, not with June 13th, in general, when you're doing investigations and reports, do you have a guideline, or how do you decide what you notate in a report and what you don't? In general investigations, not this one.
I mean, I always try to write down relevant. I always try to write down what's relevant and what's relevant.
Relevant meaning what pertains to whatever you're investigating.
Or the conversation in general, yes.
And what also could be relevant is evidence of innocence, correct?
Yes,
And that would be relevant to any investigation.
of course.
So, and we talked about this in a little bit, but you recorded other conversations and interviews going on throughout this investigation, correct?
Yes, I did.
So the next time you meet with Ms. Tristan is June 18th. Does that sound about right? I think you went through that with the state.
I have June 19th. Is that what you said?
No, sir. June 18th, Ms. Tristan met with you and Agent Rivera from the FBI.
My report says 19th.
I guess that's my point, because Agent Rivera has a June 18th, right?
Right.
And so he did a memo that the government has that gave to us.
Your Honor, that would be improper impeachment of a report that is not written by this individual.
I'm not impeaching him, Judge. I'm just talking about the investigation.
He's trying. Okay. These facts are not in evidence of this particular report.
This is how you get it in evidence, Judge. You asked about it.
It's not his report.
So we're not talking about the contents of the report, so let's, don't go into here.
May I proceed, Judge?
Overruled, yes.
And so what I'm saying is, but Agent Rivera, who you work with, notated it, this June 18th meeting,
Okay, yes, sir.
but that you were part of.
Yes.
Okay, so on June 18th, so you, Agent Rivera, Ms. Tristan, have a meeting, and that was not recorded, correct?
Correct.
And as you just stated, it's not in your report, but Agent Rivera notates it.
Okay, yes, sir.
And on that day, that's when Ms. Tristan gives you both this June 14th voluntary statement that she made. It's S8.P3.
Right, but I have it for the 19th, Mr. Hood.
No, but Rivera has had for the 18th. But regardless, you guys get this statement, correct?
Yes, yes.
Okay. And I guess this is kind of my point, but you don't have a notation for the 18th, so maybe that's why we're a little bit...
It's so hard for me to explain that.
Okay. Well,
Without-
let's try to get through it then, okay? But there's nothing wrong with that statement. The statement that she handed over to you guys.
I wear two hats. I have a Title 18 hat and a state hat.
Well, I'm going to ask you about your federal side too.
Okay, sorry.
I
Go ahead.
promise you I will.
Okay.
And so she handed over a statement to you, and it was a voluntary statement that she made back on June 14th.
So I have documented that she gave us a copy of the Sheriff Office incident report. No, excuse me. Let me make sure. Yes. Some open source media for the constable's office and copies of statements from Precinct 2 Constable Clerk.
That's right, and that's what I was referring to.
Okay.
So, yeah, her statement was this voluntary statement that she
Okay.
made on June 14th, right?
Yes, sir.
Okay. And in your review and your investigation, there's nothing wrong with her statement, right?
Right.
I mean, it's a truthful statement.
I mean, I have to assume it is, yes.
Okay. I mean, she testified to that if she was just talking about what she does in her job duties for the precinct
Okay.
and her responsibility. Do you not recall that?
I mean, I have it all here. I mean, can I look at that statement?
Sure.
I just want to be careful, that's all.
I understand, Rachel.
I think it's 46-1.
May I approach, Judge?
Yes. And I worked with the two previous drafts she also provided. I'm not really sure what those numbers are.
That first witness, Judge?
Yes.
I'm handing you what's been entered into evidence as states Exhibit 46-1.
Okay, very well, thank you.
Yes, sir. And so what I was asking you is, so this is a voluntary statement that Susan Tristan gave to Precinct 2, just describing her job duties, correct?
Yes.
And just kind of in general, would you agree that overall, your first 3 meetings with Ms. Tristan, she was nervous?
I mean, there was, you know, getting to know her demeanor, I can't say she was nervous. No, I can't say she was nervous. I didn't think she was nervous.
Okay. People don't get nervous meeting with you at all?
Initially, but as we speak, that nervousness tends to die down.
Well,
So,
I guess maybe we're talking
that's
about...
very subjective, right?
Okay, well, let's try to get through it. So,
I can't tell you what another person's feeling.
okay.
But I'm sorry, go ahead.
No, it's okay. But we have to look at kind of behaviors, and you do this for a living. You have to
Okay,
figure out...
I didn't think Susan was nervous. No.
Okay, but let me follow that up now. So you look at motives or lack of motives, right? Why somebody would do something in general when you're
Yes.
doing investigations. You look at scenarios. You look at witness statements. You look at job situations. You look at everything to try to figure out someone's intent.
Okay, yes, sir.
Because that's what you do. You look at people's intent, right?
Yes.
And so what I'm saying is, and whether when you're a tall guy, good-looking dude, right? I mean, you know, you got a big gun. I mean, so someone can be nervous talking to a ranger like yourself, right?
Of course.
Okay. And at the time, you didn't know early on. Remember, we talked about this yesterday that she knew she had shredded security agreements, correct?
Right.
She knew she was reprimanded for it early on. You didn't know at first.
I didn't know, right.
But she knew that your subpoena, you and Dawn's subpoena, was asking for those security agreements. She knew, but you didn't. I mean, you knew what you were asking for.
Mhm, yes, sir.
Okay. And so that's all I'm saying. You didn't sense any of that nervousness? Is that what you're saying?
No, I had no reason to believe she was not being completely honest.
But if, and again, that's what I was talking about in general, if your interactions with her were recorded, then the jury could see and make their own determination, right?
You know,
That's just a general statement.
I can't.
No, you see, this is what we talked about
Because
yesterday.
she was
It's not that you
listed.
can't.
Guys.
Sorry.
No, it's not that you can't. You're going to talk about your federal obligations versus your state obligations, right?
She was listed at the time as a source.
First of all, you're jumping ahead. You come in contact with somebody. She's not a source yet. She just contacted you, right?
Okay, we did not record her.
I understand, Ranger, but you say something, so I really want to flesh it out now. So she initially just contacted you.
Right.
You had no idea who this woman was, right?
She told us who she was.
I know that. I'm just saying when you first met her, you don't know.
But I knew who she was. She called because she was the clerk at the Precinct 2 office.
But you didn't
As
know.
a strategy, she wanted to cooperate, and we immediately listed her as such. We did not record her.
Are you finished?
Yes.
Okay. So now let's get back to my questions. Okay. And so when you first came in contact with her, you don't know if she's guilty of anything, right? You
No.
didn't know?
No.
You didn't know that she had shredded those security agreements that you were specifically asking for? You didn't know that, did
No.
you? You didn't know that she was reprimanded for shredding those security agreements
No.
that you and Don specifically asked for, right?
I did not know.
That's all I'm saying. And so if it was recorded, then we can make our own determinations. That's all I asked, right?
Okay.
Fair. So, as a general proposition for an investigator, when you have a witness that is nervous and willing to talk, that's a good witness for you.
You
right?
said she was nervous.
I just said as a general proposition. This for Susan Tristan aside right now. In general, if a witness is nervous and willing to talk to you, that's a good witness for you. Would you agree?
I don't know if nervousness has anything to do with that. A witness is a witness.
How about this? How about if a witness is motivated? and willing to talk to you. Is that a good witness for you?
I don't know the motivation.
How
I
about
have
if
to
the witness
talk.
wants to talk to you? Is that a good witness for you?
Yes,
Okay. Then as you talk to them, you figure out their motivations, right?
sometimes.
You hope to, right?
Yes,
Because you know that you're going to work with a prosecutorial agency to present that witness to a jury, and they need to be credible.
it's possible.
You don't want them to be credible?
No, it's possible that I would talk to a prosecutor and do what you just said, yes.
Yes, sir. And so you make an assessment of the witnesses you deal with, because you know that that has to be presented to a jury of their peers at some point.
Correct, yes, sir.
And so when you talk about identifying witnesses, we've heard terms as CHS, right?
Yes.
And what does that stand for?
Confidential human source?
And some people call it a cooperating human source, but that's a FBI term, right?
Yes.
And then there's also CS, what's that?
Confidential source?
Confidential source. And then in the state, we use CI, right?
Okay,
And that's confidential informant.
okay.
But they're all really interchangeable depending on federal or state.
Okay, yes, sir.
And you would agree when you have formal CHSs, CSs, or CIs, you have agreements. There's agreements that that person makes with this government.
I can't speak factually on that. We do not handle that.
I'm not saying you handle it, and I don't want you to go through the process of having contracts with the government. I'm saying you're aware of it, and you know if a CS or a CHS has an agreement with the government, right?
Mr. LaHood, if you say that it is, then I'll have to agree because I don't know.
Okay, I guess that's it. So you don't know whether CHSs, CSs, or CIs have agreements with the government.
That is a question that is better suited for handlers of confidential informants, confidential human sources, and the other one, CI. I'm not an expert on that, and I'm not going to claim to be.
I just want to make sure we're clear.
I do too.
We'll see. Well, here's the deal. Your testimony before this jury is that you don't have knowledge about confidential informants, confidential human sources, or cooperating sources. Just yes or no. That's your testimony to this jury.
Yeah, I'm not an expert. I don't know the rules. I don't know the contracts.
Okay? But your job ultimately is to persuade witnesses to cooperate with you. Would you agree with that?
I don't know about persuade. We ask for cooperation. I mean, if you frame it in a persuasive way, I kind of feel like that's misleading. But we ask for people to cooperate. Yes, we would like witnesses to cooperate.
And can we go back to yesterday when we talked about strategies?
Sure.
Okay. And we talked about a strategy, and it's not your fault, it's just the way it is. A strategy is that an investigator can lie to a witness.
Yes.
And that's persuasion. That's
Yes.
persuading someone to do something.
Yes, sir.
Things like, hey, man, for example, think about your family. You want to be around for your kids. Think about your plan to move. Whatever it could be for that scenario, that's your job is to persuade them to give you information.
Those are strategies that are used when officers sometimes are interviewing people.
And they're called, we hear it every day, depending on the shows that people watch, as good cop, bad cop strategy, right?
Okay.
Maybe, right?
Uh-huh,
Someone might come in and do a little strong arm, and the other one says, man, Bradley, get out of here, man. Hey, I know it's scary, but just cooperate, help yourself. Things of that nature, right? That's
Yes.
persuading somebody.
Yes, sir.
So once again, about this 618 meeting, we have to take your word for it because it's not recorded.
Because it's not recorded. That's correct.
But also on June 18th, you delivered that second subpoena.
Okay.
If you just tell me 47. May I approach, Judge? Thank you, John. Did you say yes? I'm sorry, Judge.
Yes, I got it.
We're gonna look for the second subpoena. It's just exhibit. Do you recall that on that second subpoena that you delivered, that there's no mention of cash logs? Do you remember that?
Let me see it first.
Okay, fair enough.
But I can tell you there was never a mention of cash logs. We can start there.
Yes, sir.
Okay.
But you still want to see it? Okay.
I mean, in case you're going to ask me more questions about that.
Well, that's really the main question, right?
Okay, there was never a mention of cash logs on any of the subpoenas, Mr. LaHood.
Okay. May I approach the witness, Judge?
Yes.
I'll leave these up here with you. Is that
Okay. Yep.
These are state's exhibits. So you said something right now, that there was never mention of cash logs on any of the subpoenas, correct?
That's right.
But you would agree that it's all about the cash logs in the indictment, right?
Yes, it's about the information we did not receive, yes.
But that information
That
you claim...
includes cash logs.
No, not includes. It's all about the cash logs in the indictment, right? Have you seen the indictment?
The indictment's changed over time?
Have you seen the indictment that we're in court for?
No. Remember that time?
May I approach, Judge?
Sorry. If you want to reach up here and slap me, that's fine. If you want to slap me, that's fine.
It sounded like an alarm.
God bless you. May I approach it?
Yeah.
I'm handing you what's been marked as Defense Exhibit 18 for identification purposes only. You recognize that as a copy of the indictment in this case, correct?
Yes.
And the only thing in that indictment, when it says namely, that means specifically attention driven to cash logs, correct?
Show me where it says that.
It's in the second one too.
Yes.
You can keep it there, sir. And so that's what I was asking you about. It's not also cash logs, it's cash logs.
Yes.
And as you testify to this jury, none of the subpoenas mention cash logs, correct?
That is correct.
So let's get to June 19th now, okay?
Okay.
I believe that you testified a second ago that that is notated in your report.
A meeting with Susan is notated in my report.
Yes, sir. And in your report, this is one of your longer notations, right? Because she's describing her duties to you, where she turned over the day previously in her statement.
Right.
And she's essentially talking through with you what her statement said the day before.
Yes.
And she's explaining things about responsibilities and making reservations and what she does as a clerk and how she sets up security and all that things, right?
Yes.
And she told you that she's responsible for the information at Rodriguez Park.
Yes, she says she handles the security and the information at Rodriguez. Yes, that's part of her job duties. Yes, sir.
And this, well, we'll get there in a second, but something else happens on this date, aside from your meeting with her. If you want to look at your report, she's given a formal reprimand for shredding documents.
Do I have that notated? Are you seeing?
No, you don't. I'll get there in a second.
Okay.
Okay, but you know through your investigation, not because of your report, because of your investigation, that she was actually given a formal reprimand from Precinct 2 for shredding documents.
Yes, sir.
And specifically for shredding security agreements. I think it's in evidence already. May I approach it? Bishop. Many was in evidence, it states 19.2. And so this is what I was talking about, the counseling report, right?
Right, okay.
And she was shredding documents in relation to Rodriguez Park.
Yes.
And in that counseling report, it references back to an oral reprimand she received on June 3rd, correct?
Yes.
Okay, so this is the same day you met with her, but you also find out that she's reprimanded for shredding Rodriguez Park documents, and that same reprimand talks back to an earlier reprimand of her shredding from June 3rd.
Yes, it does.
But I think you testified just a little while ago, but that's not in your report.
Right, no.
Would you agree, overall, can't speak for Tristan's mind if you haven't, she didn't tell you, but that that's a potential motive to give false information?
Your Honor, can we approach?
Yes.
The fact that you have a witness coming to you wanting to give you information, because you didn't go after her, correct?
Right,
She came to you, right?
yes.
And in your assessment of evaluating credibility of witnesses, was that something on your mind where you found out we're asking for security agreements, she admits to shredding them, she gets written up for it, right?
Yes,
More than one time, correct?
yes.
And she got reprimanded for shredding these security agreements before we subpoenaed any of these agreements. Was that on your mind at all?
I felt like Susan Tristan was a credible witness.
I know that, but and that's fine. But I was asking you something else. Was that on your mind in the scenario that I just gave
We
you?
were aware of it, sorry. Yes, we were aware of it.
So it was on your mind, but it wasn't heavy on your mind, correct?
Right.
So let's kind of fast forward a little bit, just a week later to June 25th. If you want to keep your report up, it's easier. This is where we heard testimony that Susan Tristan wears the first wire.
Okay.
Do you agree with that?
I don't believe I have. Oh, you said with June 25th?
Yes, sir.
Yeah, I don't have that documented.
I know. But you know, through the investigation, you know that she wore a wire, her first wire on June 25th.
Yes.
And yeah, we stipulated to that, okay? So now wire is a term of art, right?
Okay, yes.
Someone wears a wire. It's really a covert recording device.
Yes.
What does covert mean?
Hidden?
Or secretive.
Right.
Right, so the person that you're recording doesn't know that you're wearing it.
Right.
Covert. Can you describe the device to
No.
the jury? Excuse me?
No.
Well, why not? What law?
Federal.
Which federal law?
Code provision, but I can tell you it's prohibited.
Before I go judge, I think
Well, didn't somebody describe it as a small pocket size? I
Well,
mean, I
that's-
thought he already said that on direct.
I want to ask how it works. I mean-
Okay, ask how it works. That's different.
So so how does it work?
I don't know how it works.
You don't know how the recording device works?
I was told I could not testify about the device.
You don't want this jury to know about how this works? Well, no, it's
Your
not saying
Honor, I
anything.
object
Guys.
because there's law prohibiting him to go into the proprietary nature of the device. We weren't even able to get a
We're not
photograph.
talking about proprietary
No, we weren't even able to
information.
get a photograph of it. We tried.
I'm sorry.
So he either knows or not doesn't know,
I
and
agree,
move on.
I agree, but I mean, he's not saying he doesn't know, he says he can't. You can talk about it.
It is a small device that's used to record, and it's small enough to be concealed.
Okay. So, did you have to check it out before you had it, before you take it?
The special agent I was working with checked it out.
Because later on you have it by yourself, right? We'll get there. In our timeline, you're going to have that device by yourself.
Yes.
This device that you can't talk about, they trust you with it by yourself.
Yes.
Okay, we'll get there, I promise you. So Susan testified that the suggestion of wearing a wire came up in conversation, okay? But I want to focus on what you testified to yesterday. You testified to that, and I want to get this right, you learned that there were conversations she wanted to record, so we gave her a way to record that. Do you recall saying that to the jury?
I mean, I'm going to have to agree with you. Yes.
Okay. So, but who suggested wearing the wire? Was it you, Agent Vela, or Susan?
We asked if she would be willing to wear a wire. Yes.
So you and Agent Vela knew that she was a witness, point of contact, and before that meeting you had decided to go in there and say, let's ask her if she'll wear a wire.
We asked her if she could cooperate with us and wanted to be a source. Yes, sir.
But once again, this June 25th meeting, as you stated earlier, is not recorded, correct?
No.
And it's not documented in your report.
No.
Now, I know you were in the courtroom, but during Susan Tristan's testimony, she referred to herself as undercover.
Okay.
What does undercover mean?
That she's working with the government.
I guess it's more of a term used for law enforcement, right?
It is, yes.
I mean, for a witness, you're either a CHS, a CS, or a CI, but only undercover folks are law enforcement officers, right?
Yeah, but I can't control what she thought or how she said it.
No, I'm not. I didn't ask you. I just asked what undercover means, right? Undercover is referencing to law enforcement, right?
Yes.
So this wire on June 25th, she wears it all day long, correct?
Yes.
And nothing comes out of that wire.
That's correct.
Nothing that shows illegal behavior comes out of that secret wire, correct?
That's correct.
Do you know, because this term is going to come up in our discussion, incriminating. You know what that means, incriminating evidence?
Yes.
It means evidence of guilt.
Yes.
Right? Exonerating is evidence to show that someone is not guilty, right?
Yes.
Okay. Two other words. Exculpatory. Do you know what that word means?
Yes.
Okay, that's kind of another way of saying evidence of innocence, right?
Yes, sir.
Exculpatory. And then inculpatory is evidence of guilt.
Slow down a little bit.
Yes, sir. Inculpatory is evidence of guilt.
Yes, sir.
After that first wire, there was no evidence of incriminating behavior against Michelle Barrientes Vela.
That's correct.
But you didn't notate that in your report.
No.
You didn't notate that after CHS or CI or CS, however you wanted to classify, Susan Tristan fulfilled her obligation of wearing the covert recording device all day long, checked into her at 0700 hours, returned to us at 05, whatever, 1400. That's law enforcement for time, right? You use a different time system than...
That sounds like military time.
Okay, a lot of law enforcement do, then I apologize if you don't. Okay, returns it back to us at 5 p.m. and no incriminating evidence revealed from the wire. You didn't put that in your report.
I did not notate any of that in my report.
So if a group of individuals only had your report, that would be a big piece of information that they wouldn't have, right?
Right.
If we're looking at all the facts, right?
Right.
So the next time you meet with her is June 26th, the next day.
Okay. Yes, sir.
And she meets this time with just Agent Rivera.
Right. So it's not going to be in my report.
Well, it could be in the report, right? I mean, you could put it in there if you want to.
It's not in my report.
Could it have been in your report?
There is a report, however, but it's not in my report. It could be in my report, yes.
Right. And the way it would be in your report is it's called incorporation by reference.
Okay.
You've heard- Right? I mean, so on June 26th, see Agent Rivera's report, attachment here.
It's not in my report.
As you said, that could have been in there, right?
Yes, sir.
Okay. And on Agent Rivera's meeting with her, she hands him over the counseling report, the one that you and I just talked about,
Okay.
from June 19th.
Yes, sir.
Okay, so by June 26th, both you and Agent Rivera know that Susan Tristan has shredded security agreements.
Yes.
This June 26th date was also the original date where the information from June 11th subpoena was due.
Okay.
Do you agree with that?
Yes.
I mean, it's in the subpoena that you wrote up.
Right.
So do you recall that, or do you want to look at it again?
Sorry, I was looking at the wrong one.
Okay.
June 26th was the due date,
Okay,
yes.
so we're on June 26th, so by June 26th, but you later found out that the state and Ms. Vela's attorney agreed to an extension, right, on when it was due?
Yes.
Okay, but originally, by the original due date of information from your first subpoena, Susan Tristan had already worn 2 secret wires.
Yes.
Before Ms. Vela had an opportunity to turn anything over, you guys had already put 2 secret wires on Susan Tristan.
This is correct.
And all those cash logs that we see on June 13th, board, it's in evidence, was already given to you as well.
Yes.
So let's put all this together. So by June 13th, you knew of this term cash log.
Yes.
By June 26th, which is the original date that information was due, not even from Ms. Vela, from this custodian of record, right?
Yes.
You had already had Susan wear 2 secret wires
Yes.
and no incriminating evidence, right, on those wires.
On the wires, yes.
And again, this June 26th revelation is not in your report.
No.
So now we have 2 entries where there's no incriminating evidence, but you don't notate it on your report.
Right.
At the end of the day, on that June 26th, though, you made contact with Susan Tristan. You agree with that?
Yes.
And you found out that the only thing that Ms. Vela was worried about was getting her budget in the commissioner's court, right?
Is that notated?
Well, you listened to the wire, didn't you?
My FBI partner did, and I'm just going to have to, yes, okay.
Your Honor,
Well, let me
there's no facts and evidence suggesting what somebody else has said, which would be hearsay.
part of it.
Saying that's a hearsay.
Did you listen to the wire from June 26th?
I did not.
Have you ever listened to the wire from June 25 or 26?
My FBI partner listened to them.
Have you listened to the wires?
No.
Because you're in here testifying.
I was told by the FBI partner that there was
Objection hearsay, I guess. We can do that. I don't mind you saying it, but objection hearsay.
Sustained?
Okay, so have you ever listened to these wires?
We have done some spot listening, yes.
So now you've done some spot listening.
Yes.
How do you decide which spots you listen to?
When we know there's some talking,
That's the whole wire, right? So you spot listen to the whole wire?
no.
So how did you decide the spots you listen to?
We would get information from Susan that she did not have any conversations.
So then, no conversation, so you listen to no conversation? That doesn't make sense, Ranger. How did you decide what spots in the wire did you listen to?
When Susan would tell us I didn't get to talk to her or anything, we listened. My partner listened mostly, not me, because I don't handle that. And we deemed that there was no usable information on the recording.
Well, and usable information is information of guilt, right?
Or not guilt.
Well-
Information's information.
It's not in your report, that's my point, right?
It's not.
Okay, so the usable information for Ms. Vela is that there's evidence of innocence, and that's not in your report.
Right.
And then on June 26th, important, you found out that she had an interview for a job in Seattle, correct?
Yes.
So by June 26th, you knew that Susan Tristan had a plan for a long time to move to Seattle.
Yes.
And did you realize it was since January?
If I remember, I think she made it known she was looking forward to, doing something like that. Yes.
And so she was concerned about having to wear a wire on Friday because she had an interview Friday for this new job.
Yes.
Would you agree, you don't have to, that could be potential motive to not give accurate information to you?
I have no reason to believe Susan had motive to do anything bad.
You see,
That's what I would agree to.
I agree that you think that. But so I'm asking you, would you, and you say no if you don't want to, a witness that comes to you that knows she shredded security agreements, that knows she was reprimanded for before you even asked for them, then finds out that you and the government are asking for them, and has this plan for a long time to move, you don't think that's potential motive? And if it's no, it's no.
You remember, I would like to respond with more than a no. Is that possible? Because I don't want to be misleading. You remember you asking me about totality of circumstances?
Yes, sir.
That came into play with Susan.
Okay.
So,
Okay.
no. I
Okay,
did not believe she had any. The answer is no.
Okay, fair enough.
Okay.
And so the part you wanted to add is the totality of the circumstances.
That's right.
I'm going to use that term a lot too, okay? So let's get to July 1st. So we just finished June 26th. Now let's get to July 1st. May I approach, Judge?
Yes.
And specifically the email between you and Ms. Vela.
Oh, 40?
40.
I know you're testing my memory.
I'm sorry. Email, July 1st. I have it.
Good.
Thank you, sir. May I approach the witness, Judge?
Yes.
Ranger, I'm handing you what's been introduced into evidence that states Exhibit 40. You recognize that, correct?
Yes.
And you recognize that? Oh, please. Yes, thank you. And you recognize that as correspondence between you and Ms. Vela on July, I think you said 1st, and she responds on the 2nd.
Yes.
Now, just while Jason's helping me here, now, by this time, we know that you've had cash logs since the 13th, correct?
Correct.
You've had 2 secret wires by this time, correct?
Correct.
Thank you. You've had numerous conversations with Susan Tristan, correct?
Yes.
And at some time before July 1st, there has been a response to the first subpoena, correct?
Yes.
Right? I mean, because you're saying after review of your response. So,
Yes, yes.
So we don't know when it is. I'm going to talk to you about that in a second. We don't know when the response was because you didn't notate it.
Right.
And you didn't do an inventory.
Right.
You didn't do a return. With search warrants, you do a return. We'll talk about that in a second, right? You didn't do any of that.
On a grand jury subpoena?
The equivalent of a return.
That's why we asked for business records affidavit.
That's for authenticity. That's not for a jury to decide and to determine what was handed over to you.
No, we did not do a return.
Well, let me finish my question. What was handed over to you and what you did what was handed over to you, right? That's something separate.
Right.
Okay. And I'm going to get there in 1 second. So, what I do? I see it, I think. No, I don't.
Yeah, there's a zoom up and a zoom back, so do it.
So here, just so I can be clear, where do you ask for cash logs?
I never asked for cash logs.
But you knew about the cash logs, right?
Yes.
The indictment mentions the cash logs, correct?
Yes.
So we know that Ms. Vela, through her attorney, makes a response to that first subpoena sometime before July 1st, correct?
Yes.
And you would agree that that email asked for more security agreements, right?
It did.
Yeah. Some similar to the security agreements that Susan, Tristan, and shredded, right?
Speculation.
Well, she shredded security agreements?
Yes.
You asked for security agreements?
Yes.
Okay. So we know that before July 1st, and you don't know when, right? You don't know when the information was turned over? The
The
response to the subpoena.
I think the prosecutor, it was given to the prosecutor, it was
Okay.
different. So we'll have the date on when it was turned over.
Well, let's talk about that. So
It's not in my report, if that's what you're asking.
I was going to get there. Thank
Yeah.
you for covering me. So the information was given to the state, the government, right?
Yes.
And the government gave you this information.
Yes.
And we don't know when this information was received, right?
I don't have it notated on my report, but it's
Okay.
contrary to the instructions on the grand jury subpoena.
Okay. But we don't know when this was received, right?
Right.
And we don't know, well, we do know when it was scanned in. You scanned it in July 30th, right?
Yes.
So this government, through you, both of you guys, get this information in response to a subpoena. We don't know when, and you don't scan it in for at least 30 days?
The response was the 26th, no?
And then it was extended,
Okay.
right? But based off your email, there's a response before July 1st. We just don't know when. Right?
Right. That gives us like 4 days, doesn't it?
Now let's do the math. So if you get this information before July 1st, and you scan it in July 30th, that's at least 30 days.
July 30th. Okay. Yes, sir.
So for 30 plus days, we have no inventory. We don't know where these documents are, correct?
Yes.
And the reason why we talk about returns on search warrants is because you don't want, the system doesn't want the process questioned too much. I mean, we're looking for A, B, and C. We found A, B, and C. We inventory A, B, and C when we found it. We take pictures of A, B, and C. We take A, B, and C over here. This person takes over A, B, and C, God bless you, and signs off it, right? Then takes A, B, and C over here, and they sign off it, and then that's called chain of custody, correct?
Yes.
So we do that with search warrants, but with evidence against somebody accused like this, we don't have that process in place here, right?
No, not for grand jury subpoenas.
And what I just described to you was a kind of a watered-down version of chain of custody, correct?
Right.
What is the purpose of a chain of custody in general, as an investigatory process?
So you can account for every place it's been, every hand that's been on it.
And if you can't account for evidence, every place it's been, and every hand that's been on it, Why is that a problem?
It can cause doubt.
So let's talk, July 18th was that second subpoena, correct? Okay, let's look at the next subpoena there. Well, let's just kind of save a little bit of time. You have 4 subpoenas in front of you, correct?
Yes.
And none of these subpoenas mention cash logs.
Once again, we never asked for cash logs.
But she's being indicted for cash logs, just to make sure we're clear, right? In this case right here, she's indicted for cash logs, correct?
Tampering or fabricating evidence, Mr. Wood.
Namely, to wit, namely cash logs, correct?
Yes.
So let's kind of move our attention to July 24th. We're going to spend some time on that, okay? Ready? I didn't know. I'm sorry. I thought you were looking at something. So Susan Tristan meets with you again.
Yes.
And this is where she wears the third wire, correct?
Yes.
And Agent Rivera didn't give her this third wire. You did.
Yes.
How did you get that wire?
He checked it out and gave it to me.
So is that in your report?
No.
And so the purpose of this third wire, once again, was to attempt to secretly, covertly record.
Wait.
Yes, sir.
If I remember correctly, I think the agent gave it to her and I picked it up because he wasn't available to pick it up.
Because memory is an issue and stuff like this, can you check your report so we can verify that for this jury?
It doesn't specifically point that part out, but I'm relying on memory here. I think he gave it to her, and I think he was not available to pick it up, so I picked it up.
Would it surprise you to know that he doesn't have a memo on that?
No.
It wouldn't surprise you, right?
No. I mean, the fact is that she got one, right?
It didn't fall, the store didn't give it to her, somebody gave it to her, correct?
Yes.
And it was you.
She got one. I can't remember if it was me or the agent, but she wore a wire that day.
But you met with her that day.
I met with her, and if I remember correctly, I met with her to pick it up and to talk with her.
So how did she get it? How'd she get it?
If I remember correctly, I believe the agent gave it to her. Regardless, she had a wire.
Can any citizen just get wires from the feds?
No.
And so we know for sure that you meet with her early. There's no evidence that she met with Rivera, right? That day.
No.
Zero. That's not Nico the Hood talking. It's just the government. They object right now, I promise you. There's no evidence that she met with Rivera that day, correct?
Right.
But she met with you.
Yes.
And she testified she got it from you.
Her memory could possibly be better than mine.
So on this day is the plan. Is your plan? Are you and Agent Rivera's plan to try to get Ms. Vela to talk, correct?
Provoke conversation, yes.
What does provoke mean?
To garner conversation. We wanted to see if anybody would talk.
Provoke means to instigate,
Okay.
right? So if somebody provokes a fight, then that's instigating the fight, correct?
Yes.
Okay. So the plan was to provoke conversation.
Yes.
And the way that plan was going to work is instead of her wearing the wire secretly all day, and then she checks in at the end of the day, you were going to make this fake call to let them know that you wanted to meet with her, and hopefully that would get everybody nervous and talk.
That was used to see if there would be a conversation between the two of them. Yes. That was the plan.
Right.
Yes.
The plan was to try to get someone to talk, and often that kind of plan will work.
Yes.
But it didn't work in this situation,
It
right?
did not work.
So when you called, Susan was to act nervous. That was the plan. You have to convince them.
That's what you said.
Well, I mean, what was the plan? Was she supposed to say, I'm not worried, I'm just going to go have coffee with Bradley?
We asked Susan if she would be part of an interview, and we would call her, and we were going to see if that was going to start a conversation between her and the constable. How she felt, how she acted is beyond my control.
Okay, let me ask you something that you may know. But you knew that she was going to act nervous so it could provoke conversation.
How can I know that?
Because you guys talked about it. She testified to it.
So
Is her memory better than yours
the
again?
answer is no.
Her memory is better than yours again.
Quite possibly.
So you call. She acts a little nervous or whatever it is, and she goes to you, right? Correct?
With the exception of acting a little nervous, I don't know how she acted.
But you listened to the recording yesterday. I mean, after that, didn't you?
Yes.
You listened to the whole recording, didn't you?
No, I did not.
You spot listened to this one also. We'll get here in a second. How did you decide what part of this recording to listen to?
What was important is to see if there was a conversation, and there wasn't.
But how do you know unless you listen to the whole thing?
Because she would have told us.
Well, gosh, what if Susan didn't tell you that? What if Susan said that there was a conversation in there where Michelle Barrientes goes, I didn't do anything wrong. Just relax. Hold on, let me finish, please. I didn't do anything wrong. Relax. We can't tell you what to say. Someone else says, just tell the truth. Yeah, just tell the truth. That would be important, correct?
We trusted that Susan would tell us if there was a conversation had between her and anyone else in that office that we would deem pertinent.
So you trusted Susan.
We trusted Susan.
Who's we?
Me and my FBI partners.
But he's not on any reports from July 24th, is he? I don't know, maybe. Is he on your report?
No.
Oh, so you told Agent Vela, don't check the wire. There's nothing to listen to. Is that how it works?
I never said that.
Well, then how does it work then? I'm asking.
We trusted that Susan would tell us if there was anything on the recording, Mr. Hood.
So let's play this out. Can I be Agent Vela for a second? Can I do that?
Your Honor, if he's going to start saying what Rivera said, that would be hearsay.
I don't want to go into anything Rivera said. That is hearsay.
Even though he relied on it for his investigation.
Let him get him here, but we're not talking about Rivera's.
So, yes, Judge. So at some point you had to relay to Rivera that we trust Susan, don't listen to the wire.
We trusted that Susan would tell us if there was anything on the recording.
And so you understand her legal prowess, her legal background. She must have a law degree. She's gone to different training sessions on investigative techniques. She knows what incriminating evidence is. She knows what exculpatory evidence is. She knows what inculpatory evidence is. You made that assessment to trust Susan Tristan that you've known for 13 days. That's your testimony to this jury?
We trusted that Susan would tell us if there was anything on the recording that we needed to know. We trusted her. We felt that she was being honest.
That's amazing. So let's talk about words. Words matter, correct? And context of words matter? Would you agree with that?
Yes.
I want to talk about, we'll get back to the wire in a second, but I want to talk about how you used your words in that report. You use words for a living, don't you?
Yes.
You expect judges to depend on your words, correct?
Yes.
I mean, you bring a piece of paper to a judge, hypothetically, and you do this, affidavit, search warrant, and you say, Judge, trust these words on this paper and sign a search warrant. You do that for a living, correct?
I don't tell the judge to do anything.
I understand, but you say, Judge, please, pretty please trust my words?
I don't do that either. I present to them what is on the paper and they make their own judgment.
Right, but you expect them. You're not just writing for grins. You're writing so they can trust your words. Would you agree with that?
I am putting down facts that are known to me, Mr. Hood.
Do you want judges to trust your words?
I can't speculate. Yes, of course.
That's all I'm saying.
Yeah.
Okay, so you want judges to trust your words. And later on, you want juries to trust your words too, correct?
Yes.
And you want government, you want prosecutors to trust your words.
Yes.
So how you use those words matter, correct?
Yes.
May I approach, Judge?
Yes.
Yes, sir. Thank you. I'm handing you two things. I'm going to hand you what has been marked for identification as Defense Exhibit 3 and 5. And I'm also handing you what you guys have identified, you and the government, as S11P1, which we have stipulated is what you handed over to them.
Okay.
Just to clarify, 16.3 and 16.5, I think you said 3.
16.3 and 16-5. Jason's right. If I misspoke, Judge, I apologize. Will you please look at,
And 16.3 and 16.5 are just for identification?
at this point, Judge, yes.
And what was the third one?
This is, it's already in evidence. It's a copy of S11.P1 that is in evidence. Will you make sure that those are the same, please?
Yes, they look to be the same.
Judge, may I publish Defense 16.3 and 16.5? They're already in evidence.
Those are not in evidence. 16.3.
This is just for demonstrative, Judge. Yes, the original's already in evidence, but I'm using this for demonstrative. So I don't have to use the state's evidence that's already
And
admitted.
what is the S exhibit that you say is already in evidence?
May I approach, Judge?
Let's see that.
This is how they turned it over to us, S11P1, and I verified that with Dawn. It's a
Where
copy.
is it in the evidence?
Okay, so it would correspond with the cash logs that they introduced, the original cash logs that they introduced, which is...
I don't have an S11 that's been introduced into evidence.
I never introduced that into evidence.
That is not introduced.
You didn't introduce evidence?
No.
I didn't.
They're in, but they're in the 200
Oh, no, you mean
pages.
the originals, yes.
Yes, that's what I mean.
The originals have been, but I didn't do the two-page that you're describing that Susan gave to Brad. I never introduced that into evidence.
Okay. I'll do it. And you recognize Defense Exhibit 16-3 and 16-5 as copies of what Susan Tristan handed over to you on July 24th when you met with her to give her that third secret wire.
Yes.
And these are fair and accurate depictions of what she handed over to you on that day.
Yes, sir.
May I publish it to the jury? And first of all, Judge, we move into evidence Defense 16-3 and 16-5 into evidence, Judge.
Any objections?
May I see?
Yes, ma'am.
I'm sorry. So these are the copies.
Color copies, yes, of what's
Okay, because that's a little confusing.
No objection.
Then 16.3 and 16.5 are admitted.
May I publish to the jury, Judge?
Yes.
Rewind it?
Hold it below so that it's not on the other sheet.
Like this?
Yeah.
You use a specific word, I want to get it, so we'll make sure we're talking about the same thing. In your report, you used a specific word about this, correct? About this new cash logs that you have. You used the word reveal. Tristan revealed some documents that had not been given over before. You remember that?
On the 24th?
Yes, that Susan Tristan had revealed some documents that were not given before.
Yes, okay. I kept missing it, sorry.
It's okay, but that's not my word, that's your word, right?
Yes.
What does the word reveal mean to you?
They were shown to me, they were presented to me, they were given.
Well, would you agree with the definition of the make unknown or secret information known?
Okay, if that's the definition, okay.
Well, a gender reveal party is, we don't know what the gender is.
Okay, very well.
Right.
Very good, yes.
May I approach, Judge?
Okay.
So now we're looking at our chart up here. We have the cash logs that were turned over to you by Susan on the 13th, correct? Remember we talked about that?
Okay, yes,
And then we have these revealed cash logs on the 24th.
yes,
So this is just for identification. Number 3 here is the same one as number 3 here.
yes.
So there's nothing revealing about this. It's a duplicate.
Okay,
Would you agree with that?
yes,
Number 5 here is the same as number 5 here.
yes,
That's not revealing, that's a duplicate.
yes,
But if we read your report, if we don't go through this exercise, you would think the way it reads is that Susan Tristan on this date gave you something new, right?
right.
More cash logs.
Okay, yeah,
Because you said revealed cash logs, right? That's what we're talking about. Is that fair to say?
yes.
Okay. But those aren't revealed cash logs, those are duplicates.
Yeah, they're the same as the ones we collected before.
So let's talk about the use of words. Can you see that from where you're at, Ranger?
Yes,
As a demonstrative, I'm going to use 5 words and let's talk about what they mean. Can you see, Don?
Sure.
This says, I had cleaned my car, correct?
yes,
What does that mean?
clean your car.
That I cleaned my car sometime in the past, right?
Your Honor, I'm going to object to this line of questioning. It is not relevant to this case.
Thank you, Judge.
Cross.
Number 1, number 2. So in the first one, it's 5 words. I had cleaned my car. And that means something, correct?
Mm-hmm, yes,
It means I cleaned my car in the past. In the second example, it's the same 5 words, right?
yes,
But one of the words is moved, and it changes completely changes the meaning. Would you agree with that?
yes,
And on the second one, it says, I had my car cleaned. So if I tell you that, what does that mean to you?
someone else did.
That's right. But then I'm using the same 5 words,
Right.
But the order and the use matter. Would you agree with that?
I will agree, but can I add
You want to add to this? Sure.
totality of circumstances?
But in the example,
Because we're going to go back to the report.
well, hold on, but maybe, so I guess you're saying maybe I have a split personality, and I'm talking about something else in this example?
I didn't say that.
Your Honor, that's argumentative.
Well, I mean, so all I'm saying is in my example, I gave you 2 examples with the same 5 words. My simple question was, the order and use of the words change the meaning
Yes,
of the message, correct?
yes,
And clearly we know that what the 2 documents that Susan gave you, the cash logs, on July 24th were not new revealed documents, correct?
correct.
Let's go back to the 724 wire, please, the 3rd secret wire. Once again, we're going to go back to that word. Nothing incriminating came out of that wire, correct?
Correct.
It already came up. It already came up, but other significant information came up, correct, in that wire?
I don't know. Yes.
I
Okay.
mean, important information, would you say that?
Yes.
I mean, is potential evidence of innocence important?
Yes.
Okay. So important information of potential innocence came up in that conversation. With Susan and Michelle and all them in the precinct, in the wire.
Ask me again.
Okay, in the 724 wire, right, after your plan was to call and try to stir up and provoke conversation, and you did provoke conversation, right?
Yes.
You just didn't provoke the conversation you were looking for, right?
Yes, yes.
Yeah, you provoked conversation of innocence, correct?
Did I?
Well, I mean, she said, don't try not to be nervous, relax. We can't tell you what to say, just tell the truth. Things of this nature, that
Your
came
Honor,
up.
this was cleared up under the testimony of Susan Tristan, and it's hearsay.
Susan was talking to you in the wire, because we hear you in the wire, right?
Yes.
You were trying to secretly record Michelle Vela, and you accidentally secretly recorded yourself.
Okay.
You agree with that statement?
Yes.
Because you didn't know you were being recorded.
Right.
Or you forgot.
Both are possible.
But none of this significant innocence information is put into your report, correct?
No.
Matter of fact, if we didn't listen to the wire ourselves, we wouldn't even have this conversation, right? If we, our team, me and
Right.
this handsome man next to me, if we didn't listen to the wire ourselves, we wouldn't be having this conversation.
I think it was added to evidence. I mean, the recording is the recording, right?
Well, if we relied on your report, we wouldn't be talking about this, right?
Right. But my report mentions the recording.
But you relied on Susan not to listen to the report, to listen to the wire, right? Correct?
Yes.
And if we relied on Susan through you, we would never have heard this, correct?
But my report mentions the recording.
So you're saying so let me make sure we're clear, because I don't want to trick you. Remember, I know you don't trust me. So you're telling this jury that you're saying, I mentioned the recording in my report. I have no duty or obligation or will to write evidence of innocence. Is that what we need to add to your testimony?
That is not on your. All I'm telling you is that I mentioned the recording in my report.
But you mentioned recordings, you mentioned interviews, and then you spot write what you want to write, correct?
I mentioned the recording in my report.
How
That
tall
was
are you?
my answer, Mr.
How tall are you?
6'4".
I thought you'd say I mentioned recording. I thought you were going to give me that answer. So what I'm saying is you didn't want to put that in there, at least, at the very least, correct?
It's not that I didn't want to, I just did not.
Did you even know it was there, maybe?
I knew it was there
So you knew it was there. You knew that conversation was there, right?
because it's a recording.
I know.
It speaks for itself.
I agree. And that's why recordings are more reliable than someone on the stand, correct?
Yeah.
A recording is more reliable than a witness that spot checks things, correct?
Yes.
A recording is more reliable than a witness that picks and chooses what they want to put in their report, correct?
Yes.
That was my initial question, that's all. So you knew it was there and you didn't write it, correct?
I mentioned the recording in my report.
You just testified that you knew that conversation was there, Ranger Freeman, and you chose not to put it in your report.
Because there was a recording, Mr. LaVille.
So let's go back. Let's do one step at a time. You knew that conversation was in the recording, comma, and you chose not to put it in your report.
Yes, it's not in my report.
And part of that conversation that you didn't put in there was Susan Tristan telling you, she told me, don't worry about this, just be truthful. We didn't do anything wrong. That's in the wire.
Yes.
Now I want to direct your attention to August 20th, okay? Just let me know when you're ready, Major, please.
I don't have anything listed under August 20th.
Well, this is the third subpoena, correct? Or your last subpoena, the one that I think you testified, fourth subpoena that you have up there, I'm sorry, for Rodriguez Park. Can you get that fourth subpoena?
Yes, I have.
And that one was it August 20th?
Yes.
Okay, that's what I was talking about. So on the August 20th subpoena, you testified on direct examination that you wrote this out, correct?
I did, yes.
And you testified to this jury that I got the language from Susan Tristan. That's what you
Did I
testified.
say that?
Yes, sir, you did. If you don't remember, we can on a break. I can look it up.
Okay.
Do you have independent recollection of testifying to that yesterday, or of that happening?
I just can't imagine I said I got it from Susan.
I can't either, but that's what you said yesterday.
If I said it, I said it.
Okay, we'll verify it. But you definitely said yesterday, I didn't want to appear to be tricky, correct?
Yeah.
And that's why you structured this subpoena that way.
Yeah.
Now, question witness, Judge? This is the August 20th you were looking at?
Yeah, because we'll go by the date it was signed.
This one. Thank you, sir.
Because that'll trick you, right?
No, won't trick me. Thank you, though. So I'm gonna publish State's Exhibit 47-4, Ranger. And this is that fourth subpoena from August 20th. Please provide security records, deputy police officer assignments, schedules related to security for Rodriguez Park for the period of January 1, 17 to the present. Specifically, what does specifically mean?
It means specifically.
I agree. It means for this, we're going to focus on this stuff, right?
Yes.
Any documents displaying names of officers, correct?
Yes.
And the individual dates, events they were assigned to, correct?
Yes.
Along with any other related information, comma,
Yes.
such as
Yep.
time, pavilion location, correct?
Yes.
Hours worked, correct?
Yes.
Compensation received, etc.
Yes.
And so I'm going to show you State's Exhibit 31-2-15. I believe it's already admitted into evidence.
Okay.
That's an example of a security agreement.
Yep.
So you testified this is because you didn't want to be tricky, correct?
Correct.
You already know the answer. It doesn't say cash logs.
It does not say cash logs, no.
But the indictment says cash logs, correct?
Yes, it does.
So let's go through a security agreement. The one that I just showed you.
Yep.
So if you talk about officer names, we have Lugo here, correct? Officer's name.
Written off to the side, yes.
Okay, that's fine. We have the date of the event.
Yes.
Pavilion reserved.
Yep.
You even have point of contact, correct?
Yes.
We have number of guests.
Yep.
We even have a start and a stop time, correct?
Yep. Yes, sir.
All of that stuff. Oh, thank you. We have all of these things. Hours worked, pavilion location. We have all of that stuff in the security agreement, correct?
We do. It's also on that cash log.
Well, let's look at the cash logs on a consistent. Is there a line for pavilion?
No, there's not.
Is there a line for officer?
I don't see one.
Is there a line for hours worked?
I don't see one.
So you're describing a security agreement. Would you agree?
I'm describing any documents that had what I asked for.
And you got a bunch of them.
I did. Yeah.
And what you described, we just see, are not in these. These are Susan Tristan's, right? And this is her formula or her.
Those items contained everything we asked for.
Let's do it again. Where's pavilion?
The pavilion's not on there.
Where's hours worked?
It's not on there either, but you can calculate that by the hours, the compensation that was made from the cash logs.
Man, that's a lot of work, right? I thought you were
I think it's worth it. I think a police station should give it to us.
You don't want to be tricky though, right?
No, sir.
And we've gone over this quite a bit, but you knew, especially by August 20th, but it doesn't get served till when? The 20, remember you looked at it? When did it get served? I have here. When did you serve this?
I believe I served it the same day.
Does it have any information on the front when you served it? No?
No, it just says when you're honored.
So that by August 20th, you knew that you were looking for cash logs.
Yeah, yes, sir. I knew I was looking for this additional information. Yes, sir.
Well, let's figure this out. So you knew you were looking for cash logs, and Susan had given you a bunch of cash logs, correct?
Yes.
And every time you asked Michelle Vela for security agreements, she gave you security agreements.
I asked her, yes.
That's fair, right?
Yeah.
Right?
Okay, yes.
And then on this last subpoena, the subpoena that you don't want to be tricky, you don't mention cash logs, but as we went through the exercise, you more described a security agreement.
Yeah, that contains everything here. I don't know how we can factually give the public what they deserve if we're not given everything that we had asked for.
If I'm asking you for a receipt, what would you give me?
Give you a receipt, but that's not what I asked for.
I said if I. And if I ask you for, we went over this exercise yesterday, Ranger, remember? Why do we call this a receipt? And you said, because it says receipt.
Yes.
Why do we call that a security agreement? Because it says a security agreement. Why do we call those cash logs? You said, because it's obvious, we call them cash. It says cash logs, right?
Yes.
And you knew about them since June 13th,
Yes.
correct?
Yes.
You were given them the first batch. Well, we'll talk about that in a second. You were given them all on the 13th, correct?
By Susan.
But I understand, but you hadn't asked anything yet.
Okay.
You even testified to the jury that you didn't even know about cash logs on the 11th.
Right.
You asked about security agreements.
Okay.
And remember we went through that exercise? A bunch
Yes.
of security agreements. So you knew about these cash logs, correct?
Yes.
So now let's go to August 29th.
Okay.
On this date, you meet with Susan Tristan again.
Yes.
And your report states, please look at your report. What word do you use?
Before you start this line of questioning, can I give the jury a break?
Yes, Judge, please.
All right for the jury?
All right, for the jury.
All right, thank you. You may be seated. Mr. LaHood, you may proceed.
Ranger Freeman, so when we left off, we had talked about June 13th and your meeting with Susan Tristan, July 24th and your meeting with Susan Tristan and the cash log she presented to you. Now, I think before we took the break, we had left off on speaking about August 29th meeting, correct?
Yes, sir.
And this is another time that you personally met with Susan Tristan, correct?
Yes.
And your notes say, what about cash logs? She gave you what kind of cash logs?
Additional cash logs?
Right, Coach John? I'm going to hand you what has been marked, not admitted, I don't believe, Judge. It states 76. Okay, so I'm going to hand you what's previously been marked as States Exhibit 76 for identification at this time. Can you please look through States 76?
Yes, sir.
And you agree that those are copies, they're not originals, those are copies of the cash logs that Susan Tristan gave you on August 29th when you met up with her, correct?
Correct, yes.
And now I'm going to hand you Defense Exhibit 17-1. These are new, Judge. Exhibit 17-2. Defense 17-3. Defense 17-4. Defense 17-5. Defense 17-7. And Defense 17-8. Will you please compare these defense exhibits to State's Exhibit 76, please?
There's no 17.6
There's not, Judge.
on purpose.
Yes, Judge. Thank you.
Yes, sir.
And you would agree that State's Exhibit 76 is an accurate copy of what Susan Tristan handed over to you when you met with her on August 29th?
Yes, yes.
Judge, at this time, we would move into evidence State's Exhibit 76.
So you objected to the admission when they offered it, you're waiving that error?
I don't think we objected to it. I think they pulled out the wrong file, and then she said they didn't do it after all.
I have no objection to this.
So you're admitting
State
defense or
76.
states?
We admitted state 76.
State 76 is admitted without objection.
May I publish defense exhibits for demonstrative, Judge? He just testified that they were the same.
You need to show it to the state first.
Oh. You want to see both of them?
All right, yes, please. These are color copies. Your Honor, we have no objection.
Okay, you may publish to the jury for demonstrative purposes.
Thank you, Judge. I'm going to ask you about these. Remember, we're talking about the use of, I don't mean to give you my back, Ranger, I'm sorry. But we're talking about the use of words, correct?
Yes.
And the word that you chose to use in your report to describe these cash logs that Susan gave you on August 29th is which word did you just say?
Additional?
Additional. What does additional mean to you?
It means additional. She gave me more.
More, right? So if you go into a restaurant and say, I want a reservation for 5, and then 3 more people show up, you go to the hostess and say, we need 3 additional seats, correct?
Okay.
Do you agree with that?
Yes.
Okay. And so we can see, number 1, for identification here at Rodriguez Park, number 1, it's we did the color one that they have, but it's the number 1 over here that she gave you on the 13th.
Yes.
Number 2, our number 2, that she gave you on August 29th, is actually the same cash log she gave you on the 13th.
Yes.
Number 3 is number 3.
Yep.
And we can do the same with 4, correct?
Yes.
5, correct?
Yes.
And then 6, she didn't give you a copy of 6, but it was written. You later found out that was the back writing. She didn't copy the back side, correct?
Okay. Yes.
Did you agree with that?
Yes.
Okay. 7 is 7,
Okay.
and then I didn't mark it 8, but I wanted to do it in front of you, right? Can I mark it 8?
That's fine.
And then 8 from 29 is the same 8 from the 13th.
Sure is.
So in evaluating the word additional, there's nothing additional about these cash logs on the 29th, correct?
They're the same from the first one.
And the same means duplicate, right?
Yes.
But again, if we read your report, if we're just reading your report and we don't go through this exercise, the report reads as if you got more, correct?
My report says additional.
It reads as if you've gotten more, right?
My report says additional.
Does additional mean more?
Yes.
And once again, there's no recording of this meeting on the 29th.
No.
I kind of want to... And since you're in this pursuit of cash logs, Susan never gave you the cash logs between January of 2017 or December of 2017, did she?
I mean, I'd have to compare these dates, but no, I don't believe so.
And you don't have January of 2018 cash logs?
No.
And you don't have June of 18 cash logs, do you?
No.
Or July?
Right.
But you do have February 18 cash logs, correct?
Okay.
You have March 18 cash logs?
Okay.
You have April
Yes.
of 18?
Okay.
Correct? And May of 18? But then Susan doesn't, there's this gap, there's this 3-month gap. Could those be where she was shredding them? We don't know.
Don't know.
Okay. And then we have September of 2018 and October of 2018, correct?
Yes.
But then Susan doesn't give over November of 18 to January of 19, correct?
Okay.
If you recall?
Right.
But then we have February from 19 to June of 19.
Yes.
So there's these gaps in her cash logs.
Yes.
And these are her systems, right? This is her documentation system, right?
I believe so.
And she never explains why those gaps are there, right?
No.
I want to now redirect your attention now to September 23rd of 2019, okay?
Yes, sir.
This was the day that you testified on direct examination where there was a joint effort between FBI and the Texas Rangers to execute a search warrant on Precinct 2, correct?
Yes.
And I believe your report states that there were 24 agents that conducted the raid.
I'm going to go through and
Yeah,
count.
please, no, count them.
I have 23 listed, but all of them aren't agents.
Well,
But
23,
they're
then-
part of the Bureau.
Yes, sir. 23, but then you're on there too, right?
Yeah, right,
So
right.
you're 24.
Okay.
So 24 total, and 23 are federal agents.
No, not necessarily. There's some in here that aren't.
Which ones aren't?
So there's Charlie Drake. There's Dan Zamora.
Okay. Are those state officers?
Those are TFOs also, yes.
Okay. So, but all 24 of these agents or these law enforcement personnel go into Precinct 2, correct?
Yes.
And the evidence admitted in trial is relating to that search, correct?
Yes.
I want to talk to you specifically about some of the things you found and where you found them, okay? May I approach, Judge? I'm handing you what has been marked as Defense Exhibit 19 for identification.
Okay.
Defense Exhibit 20 for identification.
Okay.
Defense 21 for identification.
All right.
Defense 22
Okay.
and Defense 23.
All right.
And those defense exhibits were items and evidence found during the course of your search of Precinct 2, correct?
Yes.
And they have those yellow markers on there, right, that you were talking about during direct examination?
Yes.
And would you say that these are fair and accurate depictions of where you found these specific pieces of evidence in Precinct 2 during the search?
Yes.
And I showed these to the state judge, and I'm going to offer them into evidence and hand it over to the state for inspection and or objection.
Can you have to tell me the numbers, Mr. Levin?
Yes, Judge, I will.
Objection.
I'll repeat it, Judge. Thank you, no. So the first one, Judge, is Defense 19. Second is Defense Exhibit 20, Judge. Defense 21, Defense 22, and Defense 23.
Can I take a look at those?
Oh, yes, sir. Yes, ma'am.
These were not something that state had previously offered?
No,
Or
ma'am.
marked it?
No
Okay.
objection.
No objection, then defense 19, 20, 21, 22, and 23 is admitted.
Thank you, Judge. May I proceed?
Yes.
So, for context, as we've seen some pictures, as you made your way through Precinct 2, you came to realize that this is Susan Tristan's desk, correct?
And I can't sit here and tell you if that was her desk. I don't have any way of proving that up. You know what I mean? Like, that's a desk that's located in Precinct 2. That's my answer.
In your investigation and all your numerous contacts with Susan, she did not tell you where she sits?
No.
If she testified that's her desk, you have no reason to disbelieve her.
Right, right.
But this is a desk, correct?
Yes.
And you found some items on this desk, would you agree?
Yes.
30 and 31 was found on this desk, correct?
Yes, sir.
Let's talk about what these are. So this is that same chair. This is that desk. And this is item 30, correct?
Okay, yes.
And item 30 was a set of receipt books that were found on top of this desk that Susan testified was hers.
Yes, okay.
These were not in a safe somewhere, correct?
Right.
See, they weren't in a drawer, correct?
Right. Where's the picture?
Oh, I know that. I'm just going to go through some questions. Do you not want me to go through these questions?
Go on.
Okay. Well, they weren't found on Michelle Vela's desk, right? These, 30.
Right.
Okay, God bless you. And so, let's get a better picture of them. It's a different angle of exactly where they were found, correct?
Yes.
And they were a working receipt book.
Yes.
Let's look at State's Exhibit I'm sorry, Defense Exhibit 22. And that's a close-up of 31.
Okay, yes.
And in this 31 labeling, all of this is considered 31, correct?
Yes, I believe so.
And that includes this purple folder we keep hearing about, correct?
Yes.
So this purple folder was found on this desk that Susan claims is hers.
Okay,
Is that fair?
yes.
On direct examination, the state showed you State's Exhibit 77, correct?
Yes.
How do you go backwards, just? Okay. So State 77 is that purple folder with receipt books, but State 77 doesn't reflect where they were found, correct?
Right,
I mean, State 77 in itself doesn't reflect where this folder and receipt book were found.
right.
But it's important where they were found, would you agree? It's important where
I want... Judge, I need to speak with the prosecutor.
Okay, Ms. McCraw, your witness needs to talk to you. Pardon. You want me to come up there, or you can go meet you, you can
Yeah.
go outside.
so good to see.
Thank you, Judge Nantz. Ranger, I'm handing you what's been marked as Defense Exhibit 23 for identification. You recognize Defense 23, don't you?
I do, yes.
And this,
Not 23.
oh, it's not 23?
No, it's 24.
Jason's fault, right?
There was a photograph that you identified as 23.
Oh, I'm sorry, I thought it was next door.
Do you want me to write over, Judge, or
Yes.
give you sticker?
Right over.
I'm handing you what's been marked, now marked, as Defense Exhibit 24 for identification. You recognize Defense Exhibit 24, do you not?
Yes, sir.
And this is what you needed to take a break. You wanted to confirm, to be accurate, you wanted to confirm where that purple folder and where 31 items were placed in the...
That's right, because there's a picture with all of them together, and I knew we would be able to tell exactly where they came from.
And to go back to a previous discussion we had, well, Judge, at this time I'd like to admit into evidence Defense Exhibit 24.
No objection.
State's 20, I'm sorry, defense 24 is admitted.
And so, as we talked about earlier, this is actually part of the chain of custody, correct?
Yes.
And this is why we do it. So if you can't remember, you can go and check, and then you can say, well, this is where I found this evidence. Number one, there's a picture. You tie it to a notification here. There's other numbers here, and then we can trace it to eventually come before a jury, correct?
That's right.
And so now that we have that settled, all of the items in 31 that were placed into Defense Exhibit 24 were found on this desk, right here, where 31 is.
Yes.
And to be clear, just one copy of them, the cash logs were found in this purple folder on this desk that you placed into Defense Exhibit 24, correct?
Correct.
And Susan Tristan was the one that was in care, custody, and control of the purple folder.
Yes.
And she testified that this is her desk.
It was on her desk, yes.
And as part of your investigation, Ranger, you didn't try to ascertain or find out whose desk that was? Where you found this information?
No.
Okay. Now, once you finished, when September 23rd, the raid is done, you collect the evidence, there's a return on that, correct?
Yes.
And that bag, Defense 24, is part of that return, correct?
Yes, sir.
Now, something happened on the 24th of September. Susan executes her plan and she quits, right?
Does she quit that day? I don't know.
Part of your investigation, you don't know if she quit?
I don't recall when she left working there.
Did you talk to Susan after the raid at all?
Yes, we kept in contact with her.
How many times did you keep in contact with her?
I don't know.
Look at your report so you can refresh your memory, please.
It's going to be a minute. I just want to make sure.
Okay, no,
But just to add, the FBI kept track of her because that's part of the protocol that they use because of
sure, but
when she
is
was
that
open.
in your report also?
No.
So I know you're still looking, and if you want me to stop, I can wait. Do you want to keep looking, or do you want me to wait?
Just let me make sure.
Yes, sir.
Okay, I'm pretty comfortable.
I'm sorry, Ranger, go ahead.
So I'm pretty comfortable saying that I know there was contact with her because Dave would tell me because he has to update that, but it's not in my report.
No, but you testified to this jury that you stayed in contact with her.
We, pardon me if I said that, we meaning, myself or my FBI partners, there's an obligation of keeping track and her letting us know.
So
it wasn't
she let you know that she moved to Seattle?
It wasn't necessarily me the whole time, so if I said it was me, it was my mistake. Yes, we knew she was headed to Seattle. Yes, sir.
And that was the day after the raid?
I can't tell you what day she told us she was leaving, but we knew she was going to go to Seattle.
And that was her plan all along, to get to Seattle, right?
I can't speak factually on what her plan was, Mr. LaHood.
Well, no, you testified that remember that June 26th conversation where she said she'd been planning for a long time, she had an interview on Friday?
Yeah, so that's what she said, right?
Yes, sir.
So I'm just going to take her at her word.
So you took her at her word for everything else?
I
so
did.
you right?
I sure did, yes,
okay.
sir.
So since you trust her, so she moved to Seattle the 24th.
Okay, if she says so.
And on December 4th, just factually, 2019, Sheriff Salazar files for re-election.
Your Honor, objection. There's no relevance to when the sheriff was doing anything to this case.
I didn't say he did, I just said he filed for re-election, Judge.
Well,
Relevance?
you can ask if he knows.
Yeah.
What house of relevance?
Well,
Find out if he knows.
well, Michelle was a candidate for sheriff, Tom.
What does that have to do with Rodriguez Park?
I'm going to hold to that relevance objection. I just want to know if he knows the answer to the
Okay.
question.
You
I
know.
have no clue.
Okay.
Move on.
Okay. And you also, in your investigation, you were aware that Michelle Barrientes Vela was a candidate for sheriff, correct?
She announced the candidacy, yes. I am aware of that, yes. Yes, okay, and you're right. She was a candidate for sheriff, yes.
Because she had to step down as constable.
That's right.
correct?
That's
So
right.
she was running for sheriff.
Yes.
And so, Don, with your permission, may I share our stipulation? 20.
Yes.
And so, Judge, we stipulated that this indictment is January 20th of 2020. Is that right?
Yes.
So on January 20th, 2020, there is an indictment for this charge here on Michelle Barrientes Vela, correct?
Okay, yes, sir.
And obviously she was indicted by this current district attorney's office, correct?
Yes.
The same DA's office that actually initiated the investigation, correct?
Yes.
The same DA's office was prosecuting this case, correct?
Yes.
The same DA's office that arguably that has trial lawyers in the chain of custody of some of this evidence, correct?
Yes.
And this indictment came, if you know, 4 weeks before the primary of the sheriff race, correct?
Okay. If you say so.
If it was January 3rd, that would be about 4 weeks, correct?
Right.
March 3rd, 4 weeks. But by the time that Michelle Barrientes Vela is indicted, she's not constable anymore, correct?
Right.
There was never a threat to anyone's life or liberty, fair? Like someone's life that they were in danger about Rodriguez Park, in relation to Rodriguez Park.
No.
Okay? There was no threat to anyone's property in relation to Rodriguez Park, correct?
Right.
There was no issues from Rodriguez Park at the time of indictment over employment or anything of that nature, correct? Of anybody's employment, was that issue?
Of anybody's employment at the constable's office?
Yeah, nobody was afraid of being fired or of that nature at that time of the indictment. At the time
Out of her office?
She wasn't the constable at the time, remember?
Right,
Yeah, that's what I'm saying.
okay.
So
Okay, out of precinct 2 then, okay.
she's no longer the constable, is my point.
Okay.
Fair enough? Ultimately, Ranger, you agree, because you've given your opinions, but you agree that ultimately it's this jury that has to decide beyond a reasonable doubt whether Michelle Barrientes Vela knew that you and Don were asking for cash logs, correct? They have to decide that, not you. They do.
Yes.
They have to decide whether Michelle Barrientes Vela knowingly concealed these cash logs that you guys were asking for, correct?
Yes.
And they have to consider these same cash logs that were found on Susan Tristan's desk, correct?
Yes.
That she had maintained, correct?
Yes.
They were found and open. It wasn't in secret in some type of vault or drawer.
Yes.
They weren't hidden,
Right.
correct? They were in Susan's purple folder.
They were.
And as Constable Michelle Barrientes Vela had access to Precinct 2 24/7,
Yes.
so she could have taken those whenever she wanted to, if she wanted to.
Okay.
Is that a fair statement?
Yeah, of course.
Pass the witness, Judge.
I have a few questions just for clarification. So, Mr. LaHood began asking you about referrals from our office. This is not the only referral we've ever made from the district attorney's office to you, is it?
It's not.
Have there been referrals before?
Yes.
And if you can recall, have any of those referrals led to no charges? Only if you recall.
Yeah, I just want to be careful. I mean, I can't recall.
That's fine. I'm sure it goes back in time.
Everything in me says that there's been some that we didn't have charges on.
Okay.
Yeah.
Across 19-1 and 2 when you were up there.
Oh, Don, I have them.
Oh, do you have it? Oh, there you go.
I didn't know that's what you were looking for. Here's two.
Okay. Yeah, this is the one I want.
And,
Let's get all those.
okay,
Do you have anything else?
just my copy of the
Okay.
report.
I'm going to hand you what's marked as State's Exhibit 19-2, previously admitted. This is the counseling report form of Susan Tristan. Will you find the date of the counseling report form? It should be up towards the top.
It says today's date, 6/19/2019.
Okay. Now, I also want you to look to the left, the date of incident that it's referencing. What are those dates?
Looks like it gives a range of dates from January 1st, 2019 to January 1st, June. That would be June, right? June 6th is June?
6 is June.
I'm tired. It's, June 1st, 2019.
Okay, and then the description of the incident, the very last line refers to documents on or about what date?
Yes, on or around June 3rd, 2019.
So that does not agree with the date of the incident.
It does not.
I'm placing State's Exhibit 19-2, the counseling report form we just spoke of, on the monitor so the jury can see it. And I want to talk a little bit about working with witnesses that you're keeping their identity confidential. And Mr. LaHood talked a lot about your reliance upon her and how you relied heavily on her to tell you things and what you believed. So, from what we see and hear, is a relationship with a confidential witness or informant or whatever you want to call them, does that develops over time?
It does, yes.
And so, hence, is that one of the reasons why there's lots of meetings with them?
Yes, of course. We try our best to corroborate different things that they tell us, and so, you know, if they want to cooperate with the government, we're gonna talk to them. We're gonna meet with them as much as we can.
Okay. And then over the course of time, Mr. LaHood has demonstrated on the board what Susan would provide.
Yes.
So let's talk about the things that she provided and how you documented it into your report. So I want to go back to specifically on July 24th of 2019. Mr. LaHood talks a lot about the importance of words, and yes, words are important. However, words would, in your opinion, words can mean different things to different people.
Yes, ma'am.
And we always don't use the same word. You're not going to use the same word that I use.
Right.
And a word can mean more than one thing.
Yes.
So, particular to July 24th of 2019, Mr. LaHood talked about the word reveal.
Yes.
And you actually used that word in your report.
I did.
And so he talked to you about that Susan Tristan gave you cash logs. And you placed in there in your report that she revealed some documents.
Yes.
I want to clarify something because it's something that I did not think that you documented in your report the same way that he asked you the question, so I want to ask you.
Okay.
So when she revealed documents to you, you had said something about she knew they were different, or what was it you said? I can't, you're going to have to explain to me what she said to you when she gave you the documents.
She gave me the documents and said she knew that these were not part of what was submitted on the grand jury summons.
So it wasn't that you were saying that it was that she revealed something new to you as different from what she revealed before. You're talking about comparing it to what was given in the grand jury documents.
Yes, ma'am.
Okay. And then from there, you were gleaning information about the content of these documents.
Yes.
And one of the things that The second.
He had all four, remember, God, I didn't take him back from him.
It's going to be 47-4. It's going to be up on the bottom now.
Do you want this up here, though?
Yeah, you can rewrite it, it's fine.
Make sure I don't have it.
Yes, that's very good.
I'm going to hand you what's marked as 47-4, which we keep referring as the second one, but it's really the fourth one. So when Mr. LaHood asked you questions about specifically what you were asking for, what is the word after specifically?
Any.
Okay. And placing that on the monitor. So this subpoena asked, and you made it very clear that at this time you were aware of these.
Yes, ma'am.
Okay. And so, I'm sorry, I'm blocking your way.
You're fine.
He talks about, in his questioning of you, about specifically what you were asking for.
Correct. Yes.
And he asked you where you got that information from.
Yes.
And so you had you were able to look at these,
Yes.
and you also were able to talk to Susan.
Yes.
So looking at those documents that the defense has placed upon the board, on the heading of some of those documents, do you see the word cash log?
Cash log is not present on number 1. It says cash book if my eyes are not deceiving me. Number 2 does not say cash log. Number 5 does not say cash log. Number 6 does not say cash log. Number 8, sorry, out of order, 8 and 7 for that matter, do not say cash log.
And then in your description of also of any documents displaying the names of the officers and the individual dates/events that were assigned to, along with any other related information such as the time, pavilion location, hours worked, compensation received, etc. So that's that is very specific with words what you're looking for. Is that accurate?
That is accurate.
So you want any documents that might have that information on it?
That was the hope, yes.
Okay. So I'm going to point at number 4 of the defense. I don't know if you can see it, but does it have pavilions listed on it?
I love a challenge. And no,
Oh,
I
I'm
can't.
sorry.
I'd have to get up.
Okay, let me just hand you the equivalent. That is the equivalent of State's Exhibit 31-2-4. And then you can see, does it have pavilion information on that document? And it's often referred to as P1 or P2.
Oh, okay. Yes, it does.
Okay, and let's see. So you can also look at some of these other documents, such as number 4. Does it have the names of officers? And that's not what is in your hand. Number 4. Does it have names of officers on it?
It does.
And that would be. I have them all in my hand. Do you have more of these? Can you see if there's more cash logs? I don't think I have everything. So let me put that back. I'm gonna put 31-2-4. Here's one of the cash logs found. And you can see that this is the same one as number 4 on the defense chart. And in this, can you see, you asked for, put this right here.
I saw it. You passed it.
I did.
I think that's it.
No, that's the video.
Okay.
It's in my hand. Here. Thank you. So I want to go through each of those descriptive items that you requested
Okay.
and compare it to what you did not receive. So what was the first item after any documents, specifically any documents?
Displaying the names of the officers and the individual dates/events they were assigned to.
Okay, let's stick with the names of the officers. So that is State's Exhibit 31-2-4. Did you receive this in the grand jury items?
I did not.
Does that display the names of the officers?
It does.
I'm going to place 31-2-5 on the monitor. Does that display the names of the officers?
It does.
I'm going to place 31-2-7 on the monitor. Does that display the names of the officers?
It does.
And the last 2 items I put up there, did you receive that in response to the grand jury subpoena?
I did not.
I'm going to place 31-2-8 on the monitor, and I know we previously talked about this in direct, how difficult it is to see, but are there some names of the officers on there? It's like here and there.
Yes, there is.
And did you receive this in response to the grand jury subpoena?
No, ma'am.
I'm going to place State's Exhibit 31-2-9 on the monitor. Are there some names of the officers listed on this document?
There it is.
Did you receive this as a response to the grand jury subpoena?
I did not.
I'm going to flip it over. just a note on the top, does it display a name of an officer?
It does.
And you've already stated you didn't get this document. I want to place 31-2-10 on the monitor. Does that display some of the names of officers?
It does.
And did you receive this as a response to the grand jury subpoena?
I did not.
I'm going to turn it over. On the back side, does it also have any indication of an officer's name on the document?
It does, and it goes back to the P2s on there also. Yes, ma'am.
Okay. I'm going to place on the monitor 31-2-11. Does that display some of the names of the officers?
It does.
And was that returned in the grand jury subpoena?
It was not.
I'm going to flip it over. And are some names listed on the back side as well?
There is.
And I'm going to place, I think we've already talked about 30, no we haven't. 30, I'm going to place 31-2-6 on the monitor. And I'm going to move on to, what's your next descriptive item after the officers' names?
And individual dates/events they were assigned to.
So does the exhibit 31-2-6 that's on the monitor, does it have some indication of event dates?
It does.
And as we know, this was not provided in the grand jury subpoena response.
Yes.
So I'm redirecting your attention to 31-2-7. Is there some information of events on this document?
Yes, there is.
What was the next descriptor that you had?
Along with any other related information such as time, pavilion location, hours worked, compensation received.
So clearly, amounts of money have been placed on all of the documents that you did not receive.
Yes.
And what's the next descriptor? Is there one?
No.
I'm welcome. And then I want to redirect your attention to State's Exhibit 40, previously admitted. And this document is your email to Constable Vela
Yes.
and her response
Yes.
as it relates to the June 11, 2019 records.
Yes, ma'am.
And you clarified through that communication what it was you wanted.
Yes, I did.
And even at that time, you were not aware of any of these cash logs. And you were still trying to clarify what it was you wanted.
Yes.
That's not what the evidence, he said at all, he was very much aware.
You can cross-examine.
I'm sorry, no, I meant, were you aware that they were, any documents missing? Like oh, you're right, you were, sorry.
Yeah,
Susan had met you on June 12th.
that's correct, yes.
Okay, I'm sorry. Thank you for the correction. That's good, because at that time, then you were trying to clarify with her through this communication what it was you wanted.
Right, because I knew it existed.
So then you also noted in the bottom portion of your part of the email to her, you had said you had a conversation with her when you served it.
Yes,
And she led you to believe that these sorts of things had documentation.
she did, yes.
There's been certainly a lot of talk about grand jury subpoenas. And Mr. LaHood brought up an interesting word, return. And he talked about how in a search and seizure warrant, that's common and it's actually required in a code that you make a return.
That's right.
So you obtain a search and seizure warrant through a judge, and then you make a return for the record to essentially the judge.
Yes,
And the judge actually signs the return, correct?
yes,
And we actually went through that when you testified the very first day. We were talking about dates and events involving the judge.
right.
Have you ever heard of a return on a grand jury subpoena?
I have not.
Do you know of any code provision mandating that?
No, no such exists.
There's a lot of talk about your report writing. Your report was how many pages?
94?
Okay, so that's a lot of pages. So do you document everything that everybody says in your report?
I do not.
And it sounds like just out of practicality you cannot.
Right.
And every time you have an, I'm going to use Mr. LaHood's term, evidence of innocence, are you going to write, well, they're innocent of that, they're innocent of this?
I am not.
So at some point in time, the focus of an investigation becomes on the proof you're obtaining and what that proof reveals.
Yeah, so you concentrate on what's relevant.
And you're not, I know that it's, we've talked a lot about the purpose behind an investigation, and it doesn't mean you're closed to the concept of a person possibly not being guilty of the offense you're investigating.
Not at all.
And I know that Mr. LaHood talked about some terms of art, and I believe when he refers to it as a wire, it's a term of art. However, Susan was not all wired up like we think of television, right?
No, she was not. She had a small device.
Okay. And you documented July 24th of 2019 that you provided, or at least she was carrying one of those devices with her that day.
Yes.
And it's because you were involved particularly on that day, not the other two.
Yes.
And you were part of the conversation with Susan when you were doing her interview after she came to see you at Leon Valley Police Department.
Yes.
You were one of the two people in that conversation.
I was.
So you knew what was said.
Yes.
So you didn't need to go listen to a recording about what was said between you and Susan.
Right.
And I know the search and seizure warrant has been established. It occurred on September 23rd, 2019, and that Susan left for her new job in Seattle on September 24th of 2019. And if you know, just if you know, I don't know that you know, was she aware of whether or not the search and seizure warrant was being executed?
I don't remember us telling her. I'm pretty sure we did not tell her.
Okay. And as far as when we stipulated that the indictment was presented to the grand jury on this case on January 20th of 2020, did you have anything to do with the date that I presented this case to the grand jury?
No, I did not.
And was there any communication by anyone, me, my office, your office, that we had to time it before the primary?
No.
And if you know, do you recall when Constable Vela announced she was running for sheriff?
I think it was the day of the search warrant, if I'm not mistaken.
Yes. May we approach, Your Honor?
Yes.
This is a yes or no answer. Did you believe Susan had a motive to conceal documents?
No.
And for the sake conceal or create or not provide?
No.
And had it not been for Susan Tristan providing you those cash logs, would you have known the existence of them?
The likelihood of that happening is, no, I would have never known about them.
Except and unless you executed a warrant.
Yes.
I passed the witness.
Do you want me to redirect now to it? Do you want to?
I do want you to be direct now. I warned the jurors we would go a little longer.
Okay, good. I'll don't blame me. Okay, so I'm going to kind of go over some of the things that the state talked to you about, Ranger. So she was asking, had there ever been a situation where the DA's office had made a referral to you and there's no charges, correct?
Right.
But you can't think of one incident, could you?
No, I mean, I just got to be careful. And
I understand.
I know there have been times that they've asked us to look into something and there was no evidence of a crime.
Okay. Well, but you can't think of it off the top of your head. And she was talking in general. She wasn't talking about this. She was talking about in general, correct?
Right.
Now, when she put up the exhibit of the reprimand for Susan Tristan, remember we went
Yes.
through it, she went through it. All that was doing was formalizing what she had been orally reprimanded on June 3rd, correct? That's what she was trying to talk about, those 2 dates.
If you say so, yes.
But you did the investigation. You know that's true.
I didn't write that counseling session.
I understand that, but you spoke with Susan Tristan, you know how many times, right?
Okay, yes.
You did investigations, correct?
Yes,
You requested all kinds of documents, correct?
yes,
You spoke to people, a lot of people,
yes,
correct? So you know she was reprimanded orally on June 3rd, correct?
yes.
And then June 19th was formalizing that. That's all it was doing, correct?
Okay.
Now, you testified that you work with witnesses and you develop them over time to build a relationship with them. Is that what you said?
Yes.
But it doesn't happen over 3 days, right?
It can.
It can? Or 2 weeks that really can then? Or 2 weeks?
I can't define a matter of time. I mean, it's hard to do, right? If you want me to put that into a box, it doesn't fit.
So you testified that she knew that when she handed over the cash logs, this is really important, and I don't want this to glaze over, that when Susan Tristan handed you those first cash logs, you testified, that, quote, she knew these were not part of what was submitted pursuant to the summons, correct?
Yes.
May I approach you, Judge?
Yes.
We're just going to do some calendar work now. So you're telling this jury that on June 3rd, that Susan Tristan told you, let me finish please, told you that I know that these cash logs were not submitted as part of the summons. That's what you just testified to this jury.
Okay, yeah. Let me make sure I have my dates right. Just give me a second, because I don't want to get caught up in dates and mess up. Okay, could you give me that?
But I'm just working off your words. I'm not making this up, right?
I know you're going to do that. That's fine.
Yes, sir, I'll wait.
Mr. Wood, you said June 3rd.
June 13th.
Okay.
So, if I recall correctly, June 13th she came to us. Like she didn't. Okay, just let me check, because I know that word is in here, but I don't think it was in here on June 13th, Mr. LaHood.
Yes, sir.
So if I did say it was, then that's my mistake. Okay.
I want you to be sure.
Yes. Okay, so I stand corrected. If that is truly what I said, then that's my mistake. So very early on, when she came to us, she made it known that she had made these copies because she felt uncomfortable.
I understand. That's fine.
Okay,
let's talk about this.
But I'll get to where I'll get.
We will. But I want to. You said something specific on redirect. and I know you're correct and I appreciate it, but you said a direct to this jury, confidently, that you said when she turned this over to you, that she had notified you at that time, that I know this wasn't in response to the subpoena. That's what you testified to, correct?
Okay, now I am saying,
Well, I'm asking the questions, Ranger, but that's what you testified to. I'm not making that up.
if I said that, it was a mistake.
I understand. It's because we know that there was not even a response to that subpoena until sometime before July 1st. We don't know that either because that wasn't documented, correct?
Right.
Okay. So now that we're corrected now, so when she turned these over to you, and these are the only cash logs that we're talking about, correct? Right here?
Yes.
Here, Ranger Brent?
Yes, sir. Uh-huh.
And these were in the purple folder,
Yes.
correct? And these were on tag 31 on Susan's desk.
Okay, yes.
Susan's desk. So now you're correct. So she did not tell you that these were not in response to the subpoena because no one had responded to the subpoena, correct?
Right.
You also said on direct, Ranger, you and the government went through a lot on any. May I approach Judge? You need the subpoena down up here? That subpoena that you could do. Is that it? We have it here, Don.
Okay.
Thank you. And so you guys went through this, so you harped on the word any. Right in the middle of this gumbo stew of words, any. That's how Michelle Barrientes Vela should have known, because of this word any that you were talking about, which you already had from Susan. That's how she should have known, correct?
No.
But that's what you said to Dawn, that it says this word, any other related information such as that has names and times, right?
There you go.
Right.
Keep going.
Well, I've been through this with you twice, so let's go for a third time. So they also have an application of these deputies, right? Their employment application.
It says Rodriguez Park, Mr. LaHood.
I understand that. You said any, so but it could have been in relation to Rodriguez Park because you have driver's license, you have T-code license, because they need a T-code license to work at Rodriguez Park, correct?
Yes.
Okay, so this is not clear. So if somebody would have responded to T-code license, that wouldn't have been what you were looking for.
I don't agree with that.
I know you don't. And so, but you're saying that any here made it clear that somebody should have known, to include her attorney, that you were looking for cash logs.
I am saying that with the word any, there are many following words that make it very clear what the state and the government were looking for on that subpoena.
Let's go through it again. Because remember when I was holding the security agreement in my hand when we were going over this on phone?
Yes.
And this is one of the similar security agreements that was in your hand when you wrote up the first subpoena. Remember you testified at this jury?
That's correct.
So you didn't have cash logs, you had a security agreement in your hand, and you were looking at it and you're saying, I want this information. I'm pretending I'm thinking like you. And so you're writing up your subpoena, correct?
Yes, sir.
Okay. And I've had a copy of the security agreement, and we went through each one of these things, correct?
Yep. Yes, sir.
And every one of these things are on the security agreement.
They sure are.
And Don tried to bring you over here to Susan's system. This is a copy of the security agreement, right?
Yes.
Okay. And it's in evidence, correct?
Okay, yes.
Similar security agreement that you were looking at when you wrote out that subpoena, correct?
Yes.
And it has the pavilion on here, correct?
That's not the same one, Nico, so be careful because the other one had officer's name written off to the side.
They're both in
All right,
evidence.
all right.
But thank you.
Hey, you're going to do it to me, I'm going to do the same to you.
Really? That's how you work, right?
Move along.
Is that how you work?
Ask a question
Yeah.
related to this case.
Sure. So all of this is Susan's system.
That's what Susan had, yes. That's what we understand.
Okay. And so what the state tried to do, the government tried to come up here and say, but wait a minute. And it was a challenge. I like a challenge. You had to be challenged. You mind if I stand behind you?
No.
You had to be challenged to say, I think there's a P1 in there somewhere. Remember?
Because the distance.
But you didn't even know what P1 was.
I didn't.
Today to this jury, you didn't know what P1 was. Correct?
Yes, sir.
So in your mind, it didn't have pavilion information in it.
It's got the names on it.
That wasn't my question. Let me do it back to you. So this doesn't have pavilion information in your mind because you didn't even know what P1 was.
But it's got it on there, and I didn't. At that moment, I didn't at that moment know what P1 was. No,
At what
I did
moment?
not.
At what moment?
When Don asked me and otherwise.
Yeah,
Okay.
So 7 minutes ago, it's a fake watch. 7 minutes ago, you didn't know what Dawn was talking about when she mentioned P1, correct?
Right. Yes, sir.
So surely you weren't thinking of this when you were writing up your subpoena on June 11th.
That's not true.
I don't even know what to say. So you're telling this jury, let's look at them together. You're telling this jury that 7 minutes ago, you testified to them and you didn't know what Dawn was talking about when she referenced P1. But on June 11th, 3 years ago when you're writing up this subpoena, you knew exactly the P1 meant pavilion on that cash log that you had already? Is that what you're telling them?
I just told you I didn't know, Mr. LaHood.
I asked you a separate question. I know that. Are you telling this jury that on June 11th, you knew that P1 in this little scribble, that is Susan's system, was referencing Pavilion 1?
I did not know.
I know you didn't. And all the other cash logs don't have pavilions on them. That's just that one scribble that Susan put P1 on, correct?
Okay.
Well, maybe you can look at them, right? They don't have pavilion on it.
Right.
They don't have a column that says pavilion, correct?
Right. No.
The cash log is not created to document pavilion. Is that fair enough?
Okay. Yes.
It doesn't have a column for event and hours.
Yes, sir.
The cash logs were not created by Susan to document the hours of the event, correct?
Yes.
Because this is Susan's system.
Some of them have the hours, if I'm not mistaken.
I got it. They have the names too, but this is Susan's system, correct?
Yes.
The same system that she handed over to you on June 13th, correct?
Yes.
After you asked for security agreements.
Yes.
That you got a bunch of them.
Yes.
Now, there was a question asked on, may I approach, Judge? On your direct, I believe the government asked you some questions. And made reference to why on one of the copies, because you're only getting copies from Susan, correct?
Right.
You're not, the originals were found in that blue folder, correct?
Yes, sir.
On her desk, correct?
Yes, yes.
During the raid. But there are some of these, one in particular, if you look at it, that has an addition when she gave it to you later versus when she gave it to you early on. Correct?
Okay, yes.
And the reason why there's more, we look at 1 and 1, is because she kept the original. Correct?
Okay, yes.
This cash log was a working document, right? It was on her desk?
Yes.
Okay, so when she gave you the first copy, she didn't give you the original, she kept the original and kept writing on it until you guys rated it and picked the originals up on September 23rd.
Okay.
Is that fair?
Yes.
Because that's what this shows. This wasn't information added by Michelle Barrientes Vela. This was information that Susan Tristan was continuing to use between June and September when you guys raided the office.
Yes.
And when I was talking about a return, let's get to the grand jury subpoena. The government asked you some questions about grand jury subpoena. You knew I wasn't saying that there was an official return for a grand jury subpoena. You knew that, correct?
No.
You did know that. Okay, well, I was using an example. I said, like a search warrant, there's a return.
Okay.
Remember that question?
Right. Mhm.
I was just saying there's no documentation. The government's not going to be able to provide, nor are you going to be able to testify when you received the response from Ms. Vela's attorney and what you did with it, correct?
Yes.
But we know for sure that you guys received the response sometime before July 1st, correct?
Yes.
But you didn't scan it in until July 30th, right?
Right.
And so let's go back to your investigatory skills and your experience overall. If there's a blood draw from somebody on a intox manslaughter, intox assault, and chain of custody matters on a blood draw, correct?
Yes.
Because you're looking for the blood alcohol concentration of the person accused of that allegation.
Yes.
Okay. And like that bag, it needs to be documented, inverted, stored properly, correct?
Yes.
Sent over to Austin to put in the gas chromatograph, right?
Right.
Okay. Well, if the government loses that blood for 30 days, that's a problem with the blood, correct?
Right.
So you have to account for all that time.
We're talking about the difference between blood and paper. Blood is time sensitive. The testing of blood is time sensitive. Paper is not so much.
Well, I don't want to bore them with blood and temperatures and coagulation. I understand all that. But I'm making an example, the chain of custody and knowing where your evidence is. Whether it's blood, a knife from a murder scene, a gun, you need to know where that is at all times so you make sure nobody else touched it. Is there any fingerprints? Was something taken out? Anything like that, correct?
Yes.
So having gaps like that is not a good thing in general. Is that a fair statement?
Depends on if it's a time sensitive or a matter that it's time sensitive, Mr. Lewis.
So forever your
There are
testimony...
always extenuating circumstances.
Okay. Okay. So your testimony is that evidence, whatever the evidence is, a 30-plus day gap is okay. Depends.
There are times when that could be okay. Yes, that's what I'm saying.
But there's no reason. It's not okay here. Would you agree with that?
No.
It's not okay here.
No, I wouldn't agree with that.
Okay. You're entitled to that. The government also asked you that you said you would not write in your report specifically there was evidence of innocence because she was looking at kind of phrases I was using, terms of art I was using. Remember that line of questioning?
Yes, yes.
And you said, no, I would not write evidence of innocence specifically, right?
Okay.
You would not use that phrase in your report. In general, you don't use that terminology.
No.
Is what I'm saying. But you would say, if a suspect said, I didn't do anything wrong, that's important.
Yes.
If the suspect tells a witness, the main witness, just tell the truth, that's important.
Yes.
If the suspect tells the main witness, relax, you're going to be okay, that's important.
Yes.
And that's in response because the witness faked her nervousness and they were saying, relax, you're going to be okay, right? That'd be important.
Yes.
And if the suspect told the main witness, just do what's right, that would be important.
Yes.
None of that's in your report,
It's not.
but it's on the wire.
It's on the recording.
We'll wrap up with this here. So the government asked you a specific question. Okay. And you said, I don't believe Susan Tristan had a motive to conceal anything from me, correct?
Right.
You don't believe that potentially a witness, the main witness, that shredded security agreements, I'm going to give you a list, written up for it, knows that the government's looking for what she shredded, has a plan to move to Seattle, and is afraid she's going to get in trouble for what she shredded? You don't think that's a potential thing that you should flush out and look into?
Susan Tristan gave us no reason to distrust her or not believe what she was saying.
Well, that's fine that you think that. I just asked you a completely different question. I gave you a scenario And I just asked you a simple question. You don't think that's something to look into, those things that I said?
I answered your question.
So you don't think that's something you should look into?
I answered your question.
You don't want to answer my question, right?
Susan Tristan gave us no reason to disbelieve her or not trust her.
Even though she shredded security agreements, right? Right?
Yes, according to her counseling sheet, yes.
And she was reprimanded for it.
Yes.
And you specifically had this security agreement in hand when you asked for the security agreements in the subpoena, correct? Correct?
Yes.
That was served on the constable's office, and everyone knew that you guys were looking for the security agreements, right?
Yes.
And she knew she had shredded them, correct?
Yes.
And she had been planning to go to Seattle for a long time, right? Correct?
Yes.
And listen to my words. I'm not saying that she did do something. I'm just saying you don't think that's something to flush out. That's all. No?
I am saying Susan Tristan gave us no reason not to believe her or distrust her. That's all I'm saying.
And she didn't give her coworkers a reason to not believe her and distrust her either, right?
I can't answer that.
But yet she looked them in the eye and she tricked them and she was recording everybody, right? Right?
Yes, she went in with the recorder. Yes, sir.
That's the witness, Judge.
I just have a couple questions. It has to do with what Susan knew when she provided documents with you, and I believe there's some confusion as to those dates. So I'm going to direct you to your report, section 5. And I want you to look at what you documented on June the 13th of 2019. And without saying what Susan said, I want you to see what it was you documented in your report about her knowledge.
Well, Don, if also take a look at 4.7 for me.
Okay.
I see what's here.
I understand. So on June the 12th is when, on 4.7 is when you received the phone call from Susan.
Right.
Okay. And she related some information to you as to why she wanted to speak to you.
Yes.
Okay. And at that point in time, did she tell you about, let me approach. She described something to you, is that right? And I want to show you what's just marked as State's Exhibit 31-2-11. And this is what everybody knows is the handwritten cash logs in Constable Vela's handwriting. And I want you to read what you documented about what she described to you. Does this purport to be what she described to you?
Is this in the 4.7?
You sure? Yes, at 4.7, yes. Does that purport to what she's on the phone with you and she's relating some information to you and she's describing something to you? Is that purport to be what she describes to you?
Yes.
Okay. So then I want to move to September 13th when you met with her and she provided documentation to you and what she knew at that time when she provided documentation. And while you read that, 5.1 and 5.2, I'm going to try to find that.
I can read that?
Not out loud.
Okay.
To yourself. I'm going to try to find the exhibit. So just let me know when you've read it.
Okay, I'm good.
I'm going to approach you with State's Exhibit 73.
And does this appear to be what she provided to you?
Yes, it is.
So when she came to you with her concerns, she was giving you, I'm sorry, I'm blocking off. I placed it on the monitor. She's giving you copies of cash receipts. Does that appear to be accurate?
Right. Yes, ma'am.
And then on the very back, she has a few different things. One of them is what we've come to know. I'm sorry, jury. I don't know. Can you see that?
Yes.
Okay. It's the handwritten cash log by the defendant's writing.
Yes.
And there's a second page of one of those, a third page of one of those, and then finally there's this is actually in Defense Exhibit 10, and this is Susan's handwriting, but she's memorializing a transaction with Reyes on Easter Sunday.
Right.
So on that day, she did not say to you, she knew it was not included in the grand jury subpoena?
No, she did not.
Okay. The day she said that to you, I'm going to direct your attention to your report for July 24th, 2019. This is well after the grand jury subpoena.
Yes.
So, in your report, I want you to read 11.2 to be very clear what she told you she knew at the time she gave you even more documents.
During that time, she said she revealed some documents she knew that were not given as part of the grand jury subpoena.
So it wasn't until well after the grand jury subpoena was served that she knew that these documents weren't in there.
Correct, yes.
And there's been a lot made about the fact that she was giving the same thing over and over to you, and you would write in your report additional. You didn't say they were different. You just said that was additional.
Right.
And I do want to go back to the grand jury subpoena. And I agree with Mr. LaHood that words matter. And when you draft a grand jury subpoena, do you consider what it is that you're placing into the request?
Of course.
And I want to point out, and he tried to imply that this could mean many, many different things.
Yes.
So I do want, in a plain reading of this, certainly we'll leave it to the jury to interpret what it was being asked for. However, I want to point out, it does give a such as, and it talks about pavilions and hours worked and compensation received. That does not sound like personnel files or things like that of officers.
No.
Pass the witness, Your Honor.
If I asked you to wit, what does to wit mean?
To bring?
To wit. No. What does it mean? Do you know?
No. I don't know right now.
I know.
I'm tired.
I mean, so that's why, I mean, Ms. Vela got a lawyer involved, right? To make sure that she can comply, not because she was afraid, just to comply with what they were asking. You knew about that.
You asking my opinion? Yes. Yes. I knew she had an attorney. Yes, sir.
Yeah, it's stipulated, he testified, we know that, right?
Yes.
Okay, so she's not trying to figure this out on her own, she's getting help,
Right.
right? And the jury heard how he testified on his own, but you said in the report, the 7/24 report, so we're back to July 24th, you just testified that she knew they were not given in response to the grand jury, these cash logs.
Yes, sir.
May I approach, Judge?
Yes?
That when you met with Susan Tristan here, she knew that these two duplicate cash logs that she had already given you on June 13th were not responded to by Ms. Vela's attorney.
Right.
But she never explained how she knew that. She didn't testify she's part of any inside knowledge, right? I mean, you knew that.
Right.
But yet she told you, and because you trust her, and you didn't do this exercise, it seems like, right? What I'm doing here with you, you didn't do this and compare that these are just duplicates. You had not done that before. You had not done this exercise before.
To say I didn't know they weren't duplicates is disingenuous.
Well, then now I'm even more bothered by your report, because I think it's disingenuous to say that this was revealed and that these were additional. Would you agree with that?
The total context of the paragraph gives you the understanding of what was meant.
So you want to come back here, right? Sir, you want to talk about this now?
Okay.
We will. I'm talking about this. Talking about this. You didn't do this exercise, did you?
No.
But now that we have, you know that these are duplicates, correct?
Yes.
But at the time, we got to go back now. I know it's to July 24th, when one of your many meetings with Susan, correct?
Yes.
That is not recorded, right?
Right.
They can't hear exactly how it went.
Yes, sir.
She handed you these two documents, and with confidence, she said, I know. She calls you Bradley, right?
Yes.
She says, hey, Bradley, I know for sure that these two were not given by by Constable Vela's lawyer to the government. I know that for sure. Here they are. And you wrote that in your report.
Your Honor, we need to
for lunch. Until 2:15, you remain under the same instructions. Thank you.
All right, food drink.
That he believed Tristan, that she knew before, I guess, some answer date of the subpoena, that there was stuff missing.
He testified, Judge, that, may we sit down? Is it okay for the
Yes,
phone?
we're on the record.
Okay. He testified that when she handed those two items from July 24th, that she knew that these were not in response to the grand jury subpoena.
That she knew when.
That's what I'm trying to get to, and then they want to, I mean, I'm challenging that on cross-examination, Judge, and that's where we're here. We didn't even get there, because there's no context to it. And I'm very careful how I'm asking the questions, you know that, and I'm only responding to what they asked them, so they can't ask
What
a
did
question.
they ask him?
Excuse me?
What did they ask him?
She drew his attention back to July 24th, and then she said, well, look at your report, because words matter, and Mr. Lynn said that. And then she said, what did you say in your report? Well, in my report, it says that she knew that these were not given in response to the subpoena. She didn't testify to that. It's in his report, I agree. I mean, it didn't come up. They want to bring it up. I'm just questioning it. I have to cross-examine on it.
Hasn't he already answered this, though?
They asked him on redirect, Judge. I mean, I'm not going to spend a lot of time on it if we wouldn't be here.
It was just to clarify the order of events and what she knew, because I believed when Mr. LaHood did his recross, he said that statement about knowing that Susan Tristan knew that the items were not part of the grand jury subpoena. I thought he was trying to commit Ranger Freeman to that being the June 13th date, and therefore I was clarifying the dates of when that knowledge occurred.
Judge, with all due respect to Dawn, he was testifying that on June 13th she said that statement, and I stood up and said, wait.
He did say that.
Yes, and then
Yes.
she said, oh, sorry, I was wrong. So she's trying to clarify it, and I'm just responding to
I'm
that.
clarifying it because
I wasn't confused.
in direct examination, it was on July 24th. On his cross, the date changed, and I clarified it to what is accurate and testified to the first time. It's with all these dates and all these events, especially with this report being so long, clarification is necessary because they're making a point of who knew what on what date, therefore it needs to be accurate because it's important as knowledge and motive.
Judge,
Isn't that already established?
no, Judge, they're the ones making this confusing, and
My
you
point
can't
is, it's
blame
already
me.
established.
Well,
That
they
there's
asked-
stuff missing from the report. He may have testified the wrong date.
But remember,
All of that is
but
argument.
one of their points that we question, Judge, as part of our defense, is who intended to do what. So they're trying to say that Susan told him on July 24th, which she did not testify to.
Because she wasn't allowed to.
No, July 24th, they said, she knew. I know for sure this is what wasn't responded to in the subpoena. There's no way that she knew that, but he said it, so I'm just trying to clarify that. That's the first time it had come up. So I have to cross on it. It
Because you
wasn't-
elicited the testimony, not because
I
I
did
did.
not. No, I did not, Judge.
Listen. I understand, but I think that your question has already been answered. And it doesn't matter how you ask it, his answer is going to be the same. He believed Tristan, he misspoke about the date. I mean, why are we
Because she objected, that's why. I'm not, if she would have objected, I would have moved on in literally 3 seconds, and we'd probably have passed him, and then he could go.
Well, we're going to do that when we get back from
Hopefully,
lunch. You're
Judge.
going to move on to your next question.
I will, but
And then you have some redirect or no redirect.
I don't know what his cross will entail.
I'm almost done.
Okay,
Probably
all
not
right.
much unless it.
So we're moving on.
We should be at that one homeland question.
So if that's an objection to asked and answered, that objection is sustained. Now, Oscar, back to your motive, opening the door. That's not going to go anywhere.
So, just so I can put something, can I have this portion of the record then?
Yes, absolutely.
Would the court prefer me to stand or sit?
No, you're
Okay. So, may I proceed?
Yes, sir.
Okay. So, throughout Mr. LaHood's cross, he has established and alluded that based on, I think there were 5 points, but my apologies, I wrote down 4 of them, because I lost the 5th one. But the first one was she had shredded documents. She was written up for shredding those documents. These were the type of documents that the government was looking for, and that she was moved to Seattle. And there was a fifth reason that was stated.
That she knew we wanted them.
That she knew we wanted them, which I guess was lumped into also that the government was looking for them. So those 5 things established that, or allude that she has a motivation to actually be the person that tampered and fabricated these documents. It is the state's position, and seems consistent with what the rules are, that at this point we should be allowed to present what her intent was, what her motivation was for withholding and for tampering with those documents. We can present one witness who will testify that the way that she was operating a security company without a license. For that reason, she had a motivation to withhold those documents. Simply by not allowing us to present this evidence, the jury has now only heard of one possible motivation that someone had, and we are unable to present an alternative, which is the motivation that the actual defendant in this case has.
Would you like me to respond, John?
We're simply rebutting their defensive theory, and we can foresee an argument that comes up in closing, or an argument that comes up to the jury that alludes, well, the actual person that tampered and concealed the documents was Tristan, because she had all the motivation in the world, and the state has failed to tell you why. Only one motivation has been established. And so without this court letting us present that evidence, we are with our hands tied behind our back.
Your response to if the defense says that is, Ranger Freeman testified he had no reason to not trust her. That's your response. You want to get into prior bad acts, uncharged crimes, and I'm not allowing that. And when I say this, I'm going to say this to everyone at both the council table. We already avoided a mistrial one time. So when you do your closing, you better be very careful what the words that you use. Because if you think I'm going to hesitate to hold you in contempt, I am not going to hesitate. So we're not going into anything that is not related to tampering. Period. The end. So your request to go into that and bring that witness is denied. We're going to resume at 2:15, continue with your cross. We're going to stay here all day until we finish with Ranger Freeman. Ranger Freeman needs to finish today and be excused.
Yes, Judge.
Is that clear?
Yes, sir.
Yes, sir.
All right.
Is that right here?
Thank you. You may be seated. Mr. LaHood, you may continue.
Judge, at this time, defense would like to move in to evidence Defense Exhibit 15, 16, and 17 with all its attachments in the form that is presented on the board, Judge.
State has no objection.
So let's just be clear. 15 contains 15-1 through 8. 16 is where?
In the middle, Judge, on July 24th, 3 and 5.
So how many documents are affixed to 16?
2, Your Honor. 16-3 and 16-5.
And then 17 has 17-1 through 8, but no 6.
No 6, Judge.
Okay. There being no objection, all of those exhibits are admitted.
Ranger Freeman, let's just finish off with what was provided to you by Ms. Vela's attorney in response to your subpoena, okay?
Okay.
There were security agreements.
Yes.
And we went through a bunch of them, right?
Yes.
There were receipts, and we all went through receipts, correct?
Yes.
There were other documents in relation to Rodriguez Park, like satisfaction surveys, things of that nature?
Yes, sir.
Some scheduling documents
Yes, sir.
and emails, correct?
Yes, I believe there were some emails, yes.
Pass the witness. Thank you, Ranger.
No further questions?
May the ranger step down?
Yes, Your Honor, can you keep them
Okay.
on?
Yes, so Ranger, you are excused from testifying. You still remain under the same rules that apply to witnesses while this case is still pending. Okay, thank you, sir. Please step down. All right, State, call your next witness.
State called Eddie Flores. Yes,
Did you say Eddie?
Eddie Flores, yes.
You're recalling him?
Yes, recall. Briefly, for a brief question. Oh, Judge, can I correct?
Mr. Flores, you were previously sworn. You remain under the same oath. State, you may proceed.
Judge Stanford.
Yes. All right, so before we get started with Mr. Flores, the parties have entered into an agreement with regards to an item of evidence. So it's called the Stipulated Evidence Exhibit. And it reads as follows: to the Honorable Judges of Court, Michelle Barrientes Vela's last day in possession of Precinct 2 Constable's Office facility was October 9, 2019. The current Constable, Leticia Vasquez, was sworn as Constable of Precinct 2 on October 9, 2019 after being appointed to the position. On October 10, 2019, Constable Leticia Vasquez took possession of Precinct 2 Constable's Office facility. On November 3, 2020, Constable Leticia Vasquez was elected as Constable Precinct 2 and sworn into her current role as elected Constable of Precinct 2 and took the oath of office on January 1st, 2021. That is the stipulated evidence that the parties have entered into.
Thank you, Stanford.
Yes. And you may proceed on Mr. Flores.
Thank you, Judge. Mr. Flores, you started testifying before, but based on the Texas Government Code, is an elected official a custodian of records for the agency to which they are elected to?
That's correct.
And can an agency, a business, or entity have multiple custodians of records?
Yes.
Pass the witness.
So, hey, I guess what you're saying is that I guess the primary custodian is the person who's elected in multi office, but.
Yes.
Thank you. And then, but like, for instance, if the DA's office gets a subpoena, well, Joe Gonzalez would be the custodian, but there's all kinds of custodians of records in the DA's office.
Yes.
Clerks and other people who are designated if they have the responsibility of those records.
Yes.
So Mr. Gonzalez isn't up there, at his desk filling out responses to subpoenas that come in from custodians of records.
Not to my knowledge.
Right. Okay, so I wanted to ask a little bit about, the prosecution talked to you about the fact that you're in grand jury, you're in the grand jury division, and you would be what's considered the grand jury attorney at this point in your career. That's where your assignment is, right?
Yes.
And they asked you a little bit about your experience with grand juries, a little bit about the practices and procedures. Are you familiar with a motion to compel?
Yes.
Okay, and a motion to compel, you would agree, is if somebody's not responding to a subpoena the way that the person who sent it wants it, they can file a motion to compel in a civil court or a motion to compel maybe in a criminal court that would say, hey, judge, they're not giving us what we want. Please tell them to give us what we want.
That's correct.
Okay. And that's not a tampering with evidence. That's not a felony. The motion to compel part is not charging somebody with a felony.
No.
That's just saying, hey, judge, we have a disagreement about this. Can you make them give us these documents we're asking?
That's correct.
All right. Have you ever, in your entire career, have you ever seen anybody indicted for tampering with evidence based upon not replying to a subpoena?
Hang on. Let him finish the question. Can you ask the question again?
Have you ever, in your career, ever seen anybody indicted for tampering with evidence before this based upon not replying to a grand jury subpoena?
Objection, relevance.
No, it's relevant. Go ahead, you can answer. Overruled.
Just to be clear, can you repeat the question?
So, sure. Have you ever, in your career, working with these kind of things, have you ever seen anybody, besides Michelle, indicted for tampering with evidence for not complying with the grand jury subpoena?
Well, that's a different question. So are you asking him in general, and regardless of this case? Because that's not what that sounded like.
Well, that's what okay. In general, ever, in your experience, have you ever seen anybody indicted for tampering with evidence for not replying to a grand jury subpoena?
No.
Pass it.
How many times have you done, worked on, or seen a tampering with or fabricating evidence case?
Throughout my career,
Yes. As a grand jury attorney?
as the grand jury attorney,
Yes.
I don't know the number off the top of my head, but several.
On a motion to compel, is that primarily a civil filing?
It is used in the grand jury context. With grand jury subpoena, it can be used in that context. And I'm sure in the civils.
How
as
many
well.
times have you seen that filed?
As the grand jury attorney, I have never had to do it because the documents if there's a problem with the usually if an attorney is representing a entity, a business, for example, and they have a problem, either they're claiming privilege or some sort of reason why they don't want to turn it over. It contains very, very classified, sensitive information regarding elected officials or what have you. That attorney usually knows, here in the legal community, they know I'm the grand jury attorney. They'll reach out to me, and I've always been able to reach an agreement with them.
Would that be considered a motion to quash?
Again, it's never gone to that point. They just call me, and I have always been able to work out an agreement where we obtain the records.
And so what you're describing to the jury is when someone goes that route, they actually inform the agency or the people that are seeking those records through the grand jury summons means that, hey, we've turned over stuff, but we are withholding stuff back, and if you want to try to get that, go another way.
Objective made.
Can you repeat the question?
So, in order for someone to go about that process,
Which process?
the process of filing a motion to quash or motion to compel, the grand jury or the investigator or the grand jury attorney would have to be aware that some documents were being withheld.
Yes.
And that person who is withholding the documents would have to seek some sort of reason why they're withholding those things. Is that correct?
Yes.
And so there's various reasons why someone may withhold documents, whether that be for, as you described, privilege reasons.
Or privilege or unduly burdensome. Or usually the most common request is they need more time to comply with the grand jury subpoena. And so me personally, have been pretty reasonable. I give, I work with the custodian, usually the attorney representing whatever entity it is, Frost Bank or whoever it is, whatever entity, and to extend the deadline for compliance due to the volume of records that is going to be produced.
So going back to business records and business records affidavits, should those records be accurate and made at or near the time of the event they purport to record?
Yes.
And why is that?
That's what's required legally.
And so going back to the motion to compel, the motion to quash, say someone turns over documents and then says, well, you know what, we turned over everything we had. Would that instance then require someone to then go file a motion to compel for documents that haven't even been asserted any privilege or reason for exclusion?
Your Honor, objection. It's a compound question. It's vague.
Overruled.
I would say no, because again, in your scenario, it would be the prosecutor that would file the motion to compel. So if you got the documents, then I would say no.
Nothing further, Judge.
Thank you. Mr. Flores, you remain in the same instructions.
Thank you, Your Honor.
State, do you have another witness?
We don't have any further witnesses, but we do have a housekeeping matter with one of the exhibits I need to admit.
Which one?
It's the chart I worked on with Tony Cardona and Vanessa Pena. I'm afraid it's under those.
Your Honor, I remember the chart. As long as, I think that they marked it as an exhibit number. We have no objection to it.
So I thumb through and find the exhibit number. Let me do that real quick.
I don't remember that one being that.
71.
Oh, yes. That's the chart where you did all of that.
Yes.
Okay. Any objections to the defense? I'm sorry, State 71?
No, Your Honor, we have no objection.
State 71 is omitted.
Did I admit the timeline from?
You did.
Okay.
I think those are the only two I have. And,
79 and 80.
okay, because there were 2 pages.
Oh, can I approach? Mm-hmm. That's all.
And Your Honor, at this time, the defense would like to enter or offer 3, 6, and 7, which are the demonstratives created in court. We delayed offering until this point because we didn't know if they'd be added to, and we didn't want to write on the exhibit of evidence. But
So 3, 6, and 7, any objections since the other charts with numbers?
No objection.
Defense 3, 6, and 7 are admitted. State, why don't we, can we give a break to the jurors so I can make sure the exhibits are in? I'm going to give you a quick break, ladies and gentlemen, about 15 minutes. I just want to make sure the exhibits are in order.
All right, for the jury?
Your Honor, I'm sorry, has the state rested?
No.
Okay.
No, but I want to make sure before they do that. I don't want to delay it.
That's why we're doing it. I want to do the motion to stop the record right now. But
We're not there. They haven't rested.
Right.
And that's long, so let me do one thing at a time. Let me make sure the exhibits that they intended to offer and have admitted for evidence were indeed offered and admitted, or there's a clear ruling on their admission.
Yes, Your Honor. I guess I wasn't trying to tell you that that's my preference to do. I was trying to explain to you why I was asking that question at the time.
We'll get there. We'll get
Yes,
there.
Your Honor.
I think you guys are going to have to find a way to separate all that.
Oh, it's not.
Not if it is just-
Oh, just.
Hold it.
Okay.
Jason.
Oh, I guess I think it's not in there.
Jason, we should probably secure it better. Can we take it stronger,
You
Judge?
should secure it.
And there's nothing below the witness. Okay, thank you.
Jason, can you take that down? I really need to see what's behind there. And that there's nothing else, that there's no other chart that we forgot about underneath there.
Yes, Your Honor. I could actually bring it in front of you and flip it.
Yeah, you can see like there's stuff, this is really all affixed to states too, so like,
Yeah, it is.
this
We're
is
gonna-
heavy.
Well, we're going to have it in a better position. The reason we were doing that is because this courtroom, there's limitations on space, and so we were having to do that. But I think that we're going to expand them out and have them kind of posted up in different spots around the courtroom now. Okay, so
So be careful, there's a state exhibit on back.
yes, this
There's
is
two.
this is defense 3, which we offer. That is state 80.
79 and 80 are variants, yes, for timeline.
Yes, which is the right. That's just continuation.
But the phone board itself is an exhibit, and
Yes.
that's my point. You're going to have to get rid of all these postings and let that exhibit stand alone.
Yes, Your Honor, and that was our plan.
Okay.
Now that it's continuation.
Okay. And then there's nothing else underneath your
There is.
15, 16, 17?
It's the one that just offered, there's There's 79 there, there's 78, that's state 79 and 78. There's defense 7, defense 5, and defense 3.
That were just admitted.
Yes, I believe I admitted 3-5, or offered 3-5 and 7. And that is the sum total of the demonstratives that will be unloaded from this board.
Okay? Yeah, you're gonna have to do it without tearing them.
Yes, Your Honor, what our plan was is, at the time that we discussed the charge, and during that time, we would just start to remove them so that they would be taken with
I still think we need to go over every exhibit. Don, can I see you up here? Yes. Can I see you and Jason up here? Let's do it off the record. I just want to Or State Exhibit 81, what do you have?
State Exhibit 81 is the broadcast that was from News 4 San Antonio, the Matthew Seedorf, where we were going to do the authenticity portion of the broadcast for the interview that was entered, I believe it was State's Exhibit 74.
Yes.
Also attached, and Mr. Goss and I spoke about this, is we also printed out the entire article from the internet, from News 4's website, to also attach it as part of State's Exhibit 81 for appellate purposes.
Okay, so that's admitted to be made part of the record for appeals purposes only, not as evidence in this case. Okay, we can go off the record.
Okay, mine will be.
So you put that one on this side, Oscar?
Oh, on this side.
Thank you. You may be seated. State, any other witnesses?
No, Judge, at this time, the state practice rests.
Ladies and gentlemen of the jury, let me tell you what that means. That means that the defense will have an opportunity to present any evidence that they choose to, or they can rest their case tomorrow. We have some work that we have to do outside your presence, so it's 3:30 right now. I'm actually going to release you, but I need to give you some instructions about tomorrow. Number one, you still remain under the same instructions about that I've given you from the very beginning with regards to your prohibition to look outside of anything that has happened on this witness stand, right? That's the first one. I'm going to remind you of that. Number two, tomorrow when I give you the case, what that means is I give it to you to deliberate, right? Several things will happen before. I will read you the jury charge. It doesn't take me long to do that. Then each side will get an opportunity to give their closing arguments. Once they give their closing arguments, the case is yours. I am assuming that that's going to happen around 1 o'clock tomorrow that I give you the case, which is your lunchtime, and your lunch will be ready by the time you get back there. So it's a working lunch. Okay, I want you to work. What the law says when you start to deliberate, and I don't know if any of you have any experience with this in other jury service, but what the law says is you cannot separate once you start. Once I give you the case, you don't separate. In fact, you have to surrender your cell phones to us. There will, depending on how long you go, there is always breaks that I give you in case you need to check in with your husband or your significant other, your family, just to make sure that you're okay. I'll give you an example, and this is why it's very important that your family knows you're deliberating and that I take your phones and secure them. Because there are some spouses that get very concerned when they don't hear from their wife and it's 10 o'clock at night and no one answers the phone at the sheriff's office. And so they'll come in person and be like, my wife's not answering. And so I want your family to know that you cannot separate once you start deliberating. So it's okay. I will give you breaks and I will give you your phones and you can call them and tell them still deliberating. I'm still here. Okay? So please know that. Depending on how long it goes into the evening, if we need to get you dinner, we will do that. I don't want you to worry about any of that. But come prepared tomorrow to get the case and deliberate. Okay? You have all been very patient. I appreciate you. We're going to see you tomorrow. We're going to start at 10:30. It's Thursday, so we start at 10:30 tomorrow. Thank you so much. You are under the same instructions.
All right, for the jury.
Okay, thank you. You may be seated. Defense, you said you had a motion.
Yes, Your Honor. At this time, the state having rested their case, the defense makes a motion basically for a directed verdict. I guess I'll start going count by count. And as the court knows, the way that you would look at such a motion is you would take everything in the light most favorable to the non-moving party, which in this case is the state of Texas. However, the evidence that they have presented as to each element of each count has to arise to at least a level that, taken in that light, a rational juror could find that the defendant committed or violated or that element had been proven beyond a reasonable doubt. So under the first count, under count one, the evidence has shown that that there was a grand jury subpoena. The grand jury subpoena never asked for cash logs, and that is what has been indicted. There's never been a grand jury subpoena that has asked for cash logs. And then there was in evidence is a I guess, is a response to that subpoena from the Precinct 2 Constable's office. However, inside of the response, the evidence has shown that what was asked for in the subpoena was given. Now, the specific element that we're challenging in count 1 is concealed, because the statute says that they have to, I guess, alter or conceal. But really, it's concealed. There's no evidence at all that she altered any of the handwritten cash logs in count 1. So, under conceal, there has to be some evidence that she concealed. And the state has presented no evidence by any witness that she concealed the cash logs, the evidence that's in the record. And you know, if evidence can be controverted or argued, that wouldn't apply, right? That would just be a question for the jury. But it's uncontroverted that the original documents that are used as the basis for this tampering were in Susan Tristan's possession the entire time. We introduced evidence showing that they were not, they were in the place that Susan kept them, out in the open, on the desk. They were not in Michelle Barrientes Vela's possession. There was also evidence that there were 7 other copies out there floating around. And they just haven't shown that there was any effort or any attempt by Michelle to conceal these records. And they have definitely not shown that they altered, or that she altered these records. That she scratched something out, or put something else, or whited something out. There's been no evidence of that. And there's been no evidence of concealment. And really our argument is that it cannot be inferred. So for the record, I believe, and this is how I've kind of got it in my mind, is that the handwritten cash logs by Susan, and then she also said there were some cash logs written by the defendant. The handwritten cash logs by Susan are what would be considered, I guess, count 1, the concealment. That's what they're arguing, is that these were concealed. The handwritten cash logs purportedly by the defendant would be count 2, the making, the creating of documents. There's been no evidence, though, that this creation of documents, first, there's been no evidence that the creation of that it was ever tried to be presented to anybody in order to fool them, or you know, here's the record, and it's a record I made. But I understand, and the state talked about the fact that at the time of the making, that could technically and theoretically be. If you counterfeited $100 bills and then you buried them in your backyard and never actually used one, I guess theoretically that's true. But our issue on count 2 is the element of false statement. They have never proven, and they have not proven by their by their evidence, that any of those statements that were made on those exhibits are false. They've never had anybody testify that this statement here is wrong or it's false, that anybody could know that it was false. So because they have not been able to show, and making a statement it's creating a statement or making a statement you know to be false, and then with the intent to affect an investigation, etc. None of their witnesses testified that there was a false statement on any of these documents at all. And so because they have not satisfied the element of there being a false statement in the first place, we would argue that the court should direct verdict as to count 2. So as to count 1, there's no evidence of concealment. Nobody testified that she personally concealed them, or that she took those records out of any kind of production, or that she did anything with those original records that Susan had on her desk. And in fact, she had them in her possession. Susan also did not testify, Ms. Tristan did not testify that Michelle ordered her to not turn those over, or to conceal them, or to keep them, or to do anything like that. She just testified that she had them with her. She's always had them with her. She never did have those records with her. And so for count 1, we believe that the court should grant based upon the fact that they have not proved concealed. Count 2, we believe that the court should grant based upon the fact that they have not proven a false statement.
State.
Your Honor, as to count 1, there was testimony about concealment. By not providing them in the first place, they're concealing them. We know that they weren't provided. You heard all of the evidence related to that. and certainly twice they didn't provide it. So that in and of itself is concealment. As far as the alterations, we did prove up that the documents weren't truthful, that there was misinformation placed on the handwritten logs by Michelle Vela's version. Also, as far as count 1 goes, it goes to all of those cache logs. It's not limited to just the ones minus the ones the defendant created. All of those documents were concealed from us. On count 2, as far as the knowledge of its falsity, we know when the defendant sat down to create those logs that she was doing that from the top of her head, and we showed and demonstrated by going through the whole process of recreating the information through receipt to security agreement that the information was not accurate. And as far as any intent to affect the outcome or course of the investigation, having done all of those things absolutely affects the outcome or course of the investigation. And Ranger Freeman testified as to what type of information he could have gleaned from these records had he had them in the first place in order to complete his investigation. And as far as the not providing them and who was in possession of them, as we heard testimony from ADA Flores, that the elected actually is the highest ranking custodian of record of the agency. Yes, you can designate to other people for various purposes, and she did so, and rightly so, she can do that. However, she is ultimately responsible for what had been turned over, and we know that it was her because she further clarified what was required. She knew that she had received the grand jury subpoena. She had an email conversation with Ranger Freeman further clarifying that information, so we know she was in receipt of it. We know she was in receipt of what she was expected to return. He had indication from her from the very first time that he met with her that she had indicated the different types of things she was going to produce. Just because there was from her perspective, there was not a complete set is not relevant. We know that what was there was not provided. Additionally, from that email, it says that she received them from her clerk and she handed them to her attorney, who gave them to the district attorney's office. So we knew that it went through her hands. She could have gone through those documents herself. Additionally, when she received the second grand jury subpoena, she had back what was originally delivered to us. She could have gone through those again and maybe did so, knowing that those records were not there. She could have reevaluated the grand jury subpoena with its specificity and determined that other items should have been delivered. So concealment is absolutely not an issue. And if it had not been for Susan letting us know that they existed in the first place, we would not have known and may never have reached the point where we would have had probable cause for a search and seizure warrant to recover them. And we would have been then deprived of the information of who worked out there and the scheduling of people and what information we could glean from what was recovered. And just because Susan didn't provide all of those things to us or duplicated those does not reduce the information that was recovered and not provided to us. That covers what you said.
If I may briefly respond and maybe clarify as to count 2 objection that we have. I believe that there has been testimony that the documents had different statements, but there's not been any testimony at all in front of the court about which statement was true or that this statement was false. So by saying, oh, well, it says this thing on a security agreement, there was nobody that testified that the security agreement, that was the correct thing and this was the incorrect thing or the false thing. So there has to be a level when establishing that somebody testifies that this information is false information. Not different from other information, but false information based upon something that they know to be true. And nobody has testified to that.
We know that the security agreement listed O'Neill in the margin, which was her common method of giving assignments. And we also know that the handwritten log in her handwriting listed Pena as the person who worked. And one of the reasons that might occur is because the individual at one point in time had been a reserve. And so the information she was trying to recreate in her handwritten logs was not truthful, it was false.
But Your Honor, if I could just because she brought up that specific point, the time that the security agreement they're talking about with O'Neill there, I clarified I had to take his TCOL certification up there. It was at a time in May of 2019 when he was not a reserve officer. He was a full-time officer. So they're trying to use that for motive or something, but that doesn't work. But I guess it goes back to, I know what the court has to consider now, not our arguments about whether or not there's motive, but going back to, there is not affirmative evidence that one thing is true and one thing is false, or that there was a false. There's not any evidence, and that's what this kind of motion is for, is to say, you have to at least establish a baseline of that this information that's written on here is false information. That's not been testified to and hasn't been brought in by the evidence. So that's our objection, specifically to two.
I believe the knowledge, being the mens rea of its falsity, is in the purview of the jury. They get to decide whether or not, by placing false information on the handwritten log, whether or not she intended to affect the outcome or source of the outcome or course of the investigation. She created those logs in reaction to the grand jury subpoena. I believe that's for the jury to decide whether or not she was doing it for those reasons or not.
Anything else?
No, Your Honor.
No, Your Honor.
The motion is denied. Defense, are you going to rest in front of the jury tomorrow?
Yes, Your Honor.
Okay, so I'm going to email you the proposed charge. I don't want you to leave without taking a look at it. And if you have any supplemental charges you want me to consider, please tell me before you leave.
And I haven't seen your charge. I believe that this is not going to be a particularly complicated charge.
It's not.
And so, if I think of something, would it be okay if I email the court and CC the prosecution my thoughts later on if there's something else when I get back to Patrick, who, as the court knows about
He's on the
this
email list too. I
Yes.
sent it to Patrick too.
Perfect.
So, I mean, I'm not going to stay up all night waiting either.
I understand. Anything that I would send would be before 7 o'clock.
That's reasonable. That's fine. Stay. If you can get me any supplements that you want me to consider before 7, that'd be great.
We will do that.
And then we're going to start right up at 10:30. You will close. I'll instruct them. They'll deliberate.
How long will we have for closing, I believe?
45 minutes is the tops that I give for murder cases. I mean, I can't imagine you needing more.
Your Honor, we would ask for an hour because, and I think that as the court has seen, although it's what is a tampering charge, it is a complex tampering charge with a lot of different records and elements and things that we have to go through and point to. So we would ask the court to please allow us an hour to get through all this evidence.
They would also ask for an hour just given how long and how much testimony there has been in this case. And of course, if Dawn and I can split our time.
Of course, you all can use your time however you each want to.
May we have an hour?
David, do we have an hour?
David, may we have an hour?
May we have an hour?
If it's up to him, we get 5 minutes.
That's fine. 1 hour is fine. We're not going over. I'm cutting you off at 1 hour.
Yes, Your Honor.
How soon of a clue will you give us?
Whatever you want.
Okay, we can do.
Yeah, you can tell me how much time you want in the morning.
We'll talk about it.
I tried to. I want, since we're not starting until 10:30, please have your exhibits ready